All right, graduates, thank you. Welcome everyone. It's about 11:15 in the morning on Tuesday, August 9th, and we are going to discuss the Home Rule Charter amendments relating to campaign finance regulation. Dwight, welcome.
Thank you. My name is Dwight Shellman. I'm the election manager for Pitkin County. Usually sitting to my left here and kicking me under the table is our clerk, Janice Voss-Caudill. She is out ill today. Just for the benefit of viewers, let me just quickly recap where we've been and where we are. At the June 21st work session, we came before you to alert you to the fact that the Home Rule Charter provisions relating to campaign finance set forth in Section 6.6 of the Charter are kind of out of whack with state law as it currently exists. And as a result of that, the Secretary of State in 2010 directed all Pitkin County filing entities, and by that I mean all filing entities located within Pitkin County, that they would no longer be permitted to file their organizational paperwork and disclosure reports with the Secretary of State's central filing system, and instead would be required to file with the Pitkin County Clerk and Recorder. That presented a problem, especially with respect to county political parties, because under state law, contributions to parties are aggregated at the basically county, district, and state levels, and unless they are permitted to use the centralized filing system, that aggregation becomes a cumbersome and difficult math problem for them. We initially suggested to the board that the quick way to remedy this problem would be to simply refer a ballot question repealing Section 6.6 in its entirety so that Pitkin County would no longer have unique campaign finance regulations, and all filing entities would then once again default to state law. A downside of that approach is that Pitkin County's 30-year-old contribution limit on contributions to county candidates would similarly disappear because there is no such contribution limit under state law. At the June 21st board meeting, or work session, the board indicated, I believe unanimously, that it was not inclined to refer a question repealing the charter provisions, that it wanted to retain the kind of unique aspects of Pitkin County's campaign finance regimen, and instructed the clerk and I to go back to the Secretary of State and determine whether some kind of hybrid option would be workable, where under the entities that Pitkin County is traditionally regulated, that is candidates for county offices, issue committees supporting or opposing ballot questions referred to or initiated by county electors, where those filing entities could file with the clerk subject to Pitkin County's unique filing requirements and contribution limits, while other entities, such as the county political parties, would be subject exclusively to state law and would file with the Secretary of State. We had those conversations with the Secretary of State. They were necessarily informal, and our understanding was that a hybrid option such as that would be workable. We then came before you at a work session on August 2nd, for which we basically prepared a ballot question to accomplish that hybrid result by amending Section 6.6 of the Charter so that, again, county entities would file with the clerk, everybody else would be subject to state law and file with the Secretary of State. Immediately before the last work session, however, we were advised, again informally, by the Secretary of State staff that Secretary Gessler himself was expressing a great deal of interest in this issue within the Secretary of State's office, and that a hybrid option would not or may not be workable, and that the Secretary of State staff was having further internal discussions. But the attitude from the Secretary of State had shifted from, yes, that ought to be workable, to probably not. And so at the August 2nd work session, we advised the board of that kind of change of circumstances, and I think we questioned the wisdom of referring a ballot question to amend the charter that wouldn't, or perhaps would not, actually fix the problem that we're encountering. We had a pretty thorough discussion on August 2nd with the board, and at the conclusion of that meeting, I think it's fair to say that there was kind of a division in thinking among all of you whether or not to go ahead and refer a ballot question, or alternatively to simply leave the Home Rule Charter provision alone and adopt the ordinance to fill in the gaps once we know what the rules are from the Secretary of State's office. So that is the agenda item summary that I prepared for you. In the event that you decided to refer a question to amend the charter, the resolution and ballot question have been drafted. The principal difference between the version for today's meeting and the previous meeting is that I've added a provision in the charter amendment which basically states county entities file with the county and are subject to both state law and our special requirements. Everybody else is subject exclusively to state law and files with the officer designated by state law, which is currently the Secretary of State. But I added a provision that said if the appropriate officer under state law refuses or does not permit the entities that we want to file with that officer to do so, then those people will file all the reports required by state law with the clerk and recorder. So it's just that additional provision is kind of a fail-safe filing mechanism because we just haven't got a definitive answer yet from the Secretary of State. The Secretary of State's office has advised us that they are preparing an advisory opinion which will set forth their position. We don't know yet what that advisory opinion contains, have not received it yet. And, you know, we're hearing kind of conflicting things second, third, and fourth hand. And I think at this juncture, my recommendation would be that it is difficult, if not impossible, for you all to consider a ballot question or to independently legislate on this matter on the basis of supposition and rumor and what we think the Secretary of State may do. My personal recommendation at this point would be that we leave the charter as it is. We wait to get a definitive position from the Secretary of State, which I do believe is forthcoming soon, and that we come back to the board once that position is known with an all-encompassing ordinance to fill in the gaps in the campaign finance regulatory regimen that we've adopted in Pitkin County. The timing issues there are not as pressing as those relating to referral of a ballot question. Really, what we want to do is make sure that all filing entities are required to make at least the disclosures required by state law, and the county entities are subject to the additional restrictions of the Home Rule Charter. We want to make sure that that's all clarified and in place prior to the 2012 election cycle. So, although we spent a bunch of time and killed some trees to revise the ballot question as a result of the last meeting. I just question the wisdom now of going ahead with a ballot question and think this might be better addressed by an ordinance once the landscape quits shifting. And finally, in that regard, the county manager, John Peacock, asked me to supplement the agenda item by providing a very rough outline for discussion purposes only of what an ordinance might look like. And I have done that. It's very bare bones. But again, we just want to clearly provide that Pitkin County entities proper are subject to our requirements and required to file with us. And everybody else follows state law and file with the appropriate officer designated state law. And it is the latter point, that everybody else follows state law and file with the Secretary of State, that is currently missing from our charter, although I think clearly that was the intent all along. So.
George seems to be first.
Last time when we had this discussion, the topic of a similar situation with the city and county of Denver came up. Have you talked to your counterpart there to see what they are looking at trying to do to address the same problem, or is it the same problem?
As far as I can tell, it is. The difference between the city and county of Denver and Pitkin County is that the city and county of Denver, under Article 10 of the Constitution, although it's a combined entity, it's regarded as a municipality. It therefore has the broader home rule powers of a municipality. Pitkin County obviously is a county and has the structural home rule powers of a county. However, on this particular issue, what any home rule jurisdiction, county or city, can do with respect to campaign finance and the effect of that local legislation on state law, as far as I know, there is no difference, because the Fair Campaign Practices Act specifically says either a city or a county, if you adopt your local legislation, you displace state law. There is no meaningful distinction that I'm aware of between a municipality and a county on this issue. I do not know. I know that Janice, the clerk, spoke with either her counterpart or my counterpart in the city and county of Denver and verified that political parties in the county, in Denver rather, filed both with the city clerk in Denver and with the Secretary of State's office. And there is no distinction between the type of political party that's making that filing. They are county central committees, not city central committees. And in fact, I don't know of any city central committees in the state. So there does appear at first blush to be kind of inconsistent treatment of Pitkin County vis-a-vis the city and county of Denver. I believe that is why the Secretary of State wants to do an advisory opinion on this, so that they can put in writing any distinction that may exist and why the city and county of Denver would be treated differently than us. And in fairness to the Secretary of State, I think we need to let them spell that out for us, and we'll take a look at it, obviously.
Okay. Rob, you're up next.
Logistical question or clarification in terms of these options and timing. That seems to be the most important thing here in my mind. With any sort of home rule charter change, it's got to go to the voters, and we need ballot language by September 2nd, with the first reading and a second reading happening in that time frame too. With, you had said, an all-encompass ordinance is the other option, would that mean repealing the charter in 2012, or are you talking about just filling and augmenting what we already have in the charter? And neither of these solutions solve the problem with the Secretary of State. One just needs to be acted upon timely right now because it requires a vote of our public in November.
That's correct. The reason that I'm suggesting that we proceed by ordinance is, it's a lot to ask of our electorate to take the time and to understand this thing with all of its complexity and all the various levels. And I'm not sure that's prudent when we don't know that what we're proposing actually fixes the problem. In fairness, I have to say, we don't know that an ordinance trying to do the same thing will actually fix the problem either. The benefit of just leaving the home rule charter provision alone and supplementing, filling in the gaps by ordinance, is that it's a much more flexible piece of legislation that if we do it and we say, other people, you file with the Secretary of State, and the Secretary of State says, no, this won't work for this reason, then we come back to you and say, oops, your election manager messed this up, and we need to tweak the ordinance a little bit. And it's just a much more responsive document and vehicle. Ultimately, either of these proposals does not specifically contemplate a repeal of the campaign finance provisions of the charter in 2012 or at any other time. I would suggest to you that every home rule jurisdiction of which I am aware in this state that legislates on campaign finance for many years has taken those provisions out of the charter and put it into ordinances because it's such a rapidly changing area of the law, and the ordinance is just a much more flexible document. I think ultimately that is something that the board should consider because it's an important structural issue, but that is not specifically contemplated by either of the proposals put forth to you.
And just a quick follow-up, the timing regarding the ordinance to augment our home rule charter, there isn't any specific deadline to get this done in 2011, is there? This is all revolving around campaign finances for 2012, or is there a specific deadline to get this done, before the 2011 election? Because we want to get the public the fair chance, not just if we're not doing a home rule charter amendment, we want to get the public a fair chance to understand our ordinance on home rule charter, just as we would want them to understand the ballot question on a amendment to our home rule charter.
Sure. 2 points. First, as you know, as probably all of you know, candidate committees continue until they are affirmatively terminated by the candidate. Every candidate committee that, your committee, for example, that became effective last year, yours, you haven't terminated those, and you do have a single filing required.
I terminated mine.
Oh, I'm sorry. Sorry, I didn't check my file.
I'm pretty sure.
To the extent they haven't been formally terminated, there is a single disclosure report due in, I believe it's the end of October of this year. Those are covered by, and I'll send you an email, Rob, so we have
we're going to double check that.
Those are covered by our current charter provisions. Issue committees currently, technically, are not covered at all, either by state law or by the county charter provision. And we do have an issue committee that has been formed for purposes of the 2011 coordinated election. We made it clear to them that we can't require you to file, and they did voluntarily anyway. I expect that they will voluntarily file the disclosure reports according to the state law schedule, etc. I believe the county political parties will continue voluntarily, filing the state mandated reports with us until we get this whole thing cleaned up. That's all very long way of saying there are gaps currently that we have. I believe that all of the interested stakeholders will keep complying voluntarily until an ordinance is adopted, and for that reason, I think really the drop dead date for adopting an ordinance is January 1, 2012.
Okay. So if it's fully vetted and fully understood, sooner is better. But there probably would be a drop dead date going into this fall. So my understanding, to recap, of your recommendation is to leave the charter in place as it is now, not have a charter ballot question this November.
On this issue.
On this issue, or any issue, this November.
Well, we do have the election cleanup.
The actual...
On finance.
Okay. Wait a second. I'm getting confused. The recommendation is to not have a ballot question on campaign finance, but to have a clerk's ballot question on the, quote, cleanup of reporting and public noticing and the other items.
There were two cleanup questions that were presented to you. One was basically sponsored, if you will, by Jeanette.
Right.
Those are the public notice issues.
Public notice issues.
Then we also have an election cleanup relating to, clearly specifying the eligibility for county offices, changing the primary date in our charter from whatever it says
so
now.
So you're still recommending to do those?
Yes.
By a charter change question this November?
That's correct.
Just simply not the finance?
That's correct.
Okay. So other campaign issue cleanups. And so the effect of this, if we go by ordinance, would be that the charter remains in effect and that we are plugging the holes. But if the state legislature this session passed something that affected what we have in the ordinance as opposed to in the home rule charter, would the state law overrule our local ordinance as a home rule county? Because it's not in the charter.
No, because there's no, the pertinent sentence in the Fair Campaign Practices Act applies with equal force to local legislation of a home rule jurisdiction, whether it takes the form of a charter, an ordinance, or a rule. So there is no distinction on the basis of the type of legislation.
Depends on the legislation.
Yeah.
The scheme right now is this sort of local control or default to the state. Kind of a one or the other sort of a scenario. That can change legislatively by an amendment to the Fair Campaign Practices Act. I haven't heard any dialogue like that, but I might be the last one to know. But so there could be a fundamental change to the overall picture, but the charter itself would survive and should itself be the independent enforceable document to the extent that you can reconcile it then with whatever change might be affected to the state.
Okay. Well, board members, other questions, or if anyone's willing to weigh in on what their pleasure is for proceeding on this. Jack?
I'd like to get an understanding of, because I'm not sure if I'm apples to oranges here, but indicated the Secretary of State's office has said you're either in or out. But if we, so then my question is, if we do an ordinance, say, following your recommendation, leave the home rule charter as it is, an ordinance to fill the gaps, does that mean we're all the way out? Or does that mean we're still somewhere in between?
It's a good question. To be clear, we have received kind of
Just a verbal?
conflicting verbal positions. The initial ones were a hybrid option should be doable. The later communications were a hybrid option probably isn't doable. We haven't seen anything definitive or in writing on that. Just given the timing issues involved, I think we should, frankly, whether it's by ordinance or ballot question, go ahead and provide what this board wants to provide, which we've understood to be the hybrid option. Certain people file with us, others default to state law and file with the Secretary of State. We can't force, absent a judicial proceeding or something, the Secretary of State to do what we want the Secretary of State to do. So it is possible that under either option, the Secretary of State comes back and says, no, we're not going to do that. In which event, we amend the ordinance to say, fine, all of the people that we wanted to file with the Secretary of State, you comply with state law and you file with the clerk and recorder until we can get this whole thing sorted out. The benefit of that is that we adopt a hybrid approach initially, which is what this board wants to do. We provide flexibility to kind of fill in a gap if the Secretary of State does not agree with our interpretation of what the law should provide here. And everybody is required to disclose for the 2012 election cycle until this thing gets worked out. And it may be that there's legislation in the next legislative session of the General Assembly in 2012 to address this precise issue. Because I don't know if the Secretary of State has specifically communicated with the current party chair people for the Denver County political parties. I suspect they are going to be very interested in this and are going to be aligned with Picking County on this. So, there are probably stakeholders out there who have an interest in influencing this decision, and if they can't influence it the way they want to, there may be interest in going forward with legislation to provide for the hybrid option. We just have to wait and see.
So clarification, Rachel, here.
Yeah, please.
On your recommendation, is the recommendation to do the ordinance simply to fill the gaps, or does in recommending we adopt an ordinance basically also restate our campaign, the whole deal in the charter, so basically by ordinance we would be having a complete body of campaign finance provisions within an ordinance, not just filling the gaps that are missing?
First of all, the board cannot by ordinance change the substance of what's in the charter.
Or can we continue to state it?
Absolutely.
Yeah, that's the key question.
And that's kind of a draftsmanship stylistic question, which I raised in it's section 1.2 of the supplement that I handed you. If you've ever tried to read state law, it's really frustrating. You want to find the definition of appropriate officer, the filing officer. You go to the rules, it says it's the definition pursuant to the Fair Campaign Practices Act. You go to the Fair Campaign Practices Act, and it says that term has the same meaning as Article 28 of the Constitution. So you're constantly flipping back and forth between three bodies of law, which is doable, but just as a layperson, it has to be incredibly frustrating. You can't read the legislation and find out what you're supposed to do. So my recommendation from a stylistic standpoint is let's do something in plain English, self-contained, people have one document to look at, and, legal scholars and other nerds can always look at the charter too, if they're so inclined.
Okay. Other questions? Ralph?
I'll weigh in because that was
Yeah.
primarily my question, which was, is there an advantage to having all the language in one place? Or another way of wording that, is there a disadvantage to having it in two different places? I stand pretty much in the same place that I was on the 2nd of August, which is there are certain things in our home rule charter that were voted on by the electorate here that I believe should remain in our home rule charter. If it means augmenting it now to get through the 2012 election, with an ordinance, so be it, but I don't believe that we should repeal those things that are in our home rule charter. That's my preference. I do see that there is an advantage to having it all in one place. Therefore, my first preference would be to get it all into the home rule charter in one place. The second preference would be to augment it but not repeal anything that is in our home rule charter, specifically when it comes to campaign financing levels. I don't believe that should necessarily be a decision of the board. I believe that should be a decision of our electorate, and that's a philosophical position.
Okay, so you're taking the ordinance path.
My first preference is to amend our home rule charter and have it all be in one place. That may be this year, it may be down the road.
Okay, but for clarification, we have to say this year or ordinance? Ordinance or ballot question this year?
Given the recommendation that we're waiting on the Secretary of State, I would say, for now, an ordinance to augment our home rule charter with the ideal that I won't support down the road removing things from our home rule charter.
Yeah, I agree. I don't think we would want to, well, we can't remove anything without a vote of the public. We could ask them to, but it seems a little complicated to do repeal and reenact at the same time in this ballot cycle. So I would support the ordinance direction to fill in the gaps and proceed from there. Others weighing in? Michael?
The same.
George? Same. Jack? Same. Okay. So you seem to have your direction. Are there specific questions about the ordinance or anything else that you need to let us know?
Well, we will work with the county attorney to prepare a draft ordinance and get that before you as soon as possible. Much of the drafting has been done in the form of the ballot question. We just kind of changed the style a little bit.
Right.
Just so the public understands, we went ahead and published the notice required to put the ballot question on the ballot, just to give the board the flexibility to do that if you wanted to go that way. And so as a result of the decision, you're basically saying you are not going to refer a question, and so that notice kind of dies of its own weight, I guess.
That's item number 7 under consent action, first readings tomorrow, and we can pull that from the agenda in the morning.
Jack?
As far as specifics, one thing that's a bit disturbing, and of course it's an unknown too, is the $5,000 versus the $200. We know where the $200 lies, but they didn't rule on any number. You, as our election manager, has indicated you're not qualified, not ready to make a suggestion. But why wouldn't we just adopt the $500, which we've used as a maximum in other cases, and for candidates, for example? Because this seems to be in flux anyway, but that is consistent with an element that the voters have approved.
You just mixed two different things, the 200, the 5,000, and then the 500. The 500 remains in our charter, so that doesn't go away. And the 200 versus 5,000 is the issue committee
Exactly.
reporting.
But I'm asking, why wouldn't we just substitute the $500 in the ordinance? We can always change that down the road if there's a final opinion. But I agree with those who have challenged the 5,000. That's just absurd. I mean, we've never dealt with campaign numbers in that level. So we seem to have the discretion, but there has been some historic weighing in for candidates at that level. So I'm asking, why don't we substitute the 500 for the 5,000?
The reason that you should not, in my view, automatically do that is that the constitutional considerations are vastly different for candidate committees and for issue committees. Maybe not in your mind or in my mind, but in the mind of the U.S. Supreme Court.
We're in Pickens County, right?
And the essential problem is that issue committees, according to the Supreme Court's jurisprudence on this issue, do not raise a risk of corruption because the issue is either voted up or down, and it's not like that money enables a candidate to become a public officer and then, be beholden to his or her contributors. And the Supreme Court has said repeatedly that issue committees, the regulations need to be looked at very carefully because they really impinge on people's First Amendment rights of association, assembly, petitioning their government, and so forth. And the traditional justification for upholding campaign finance regulation with respect to candidates is that the public and the government have a very real and strong interest in preventing, among other things, corruption and influence buying. And those concerns simply do not exist, according to the Supreme Court, with issue committees. So, I think maybe the parameters of what the thresholds are would be a really appropriate topic for you to discuss with the county attorney in an executive session, because there's a lot of legal consequences of that decision.
Okay, second question?
Well,
On the
let's see if
unions?
others have any comments on that
Good,
one topic
good, thank
before we jump topics. I take your advice to talk to our attorney seriously. In general, though, just looking at what the tradition in Pickens County has been, is that issue committees report, and they report everything. And the challenge for me is kind of, how do you know when you're going to pass this threshold? And suddenly you have to go backwards and do $5,000 worth of accounting and reporting and what date you received it, when you deposited it, and how you expended it. You're almost setting these people up for a disaster by letting them run to the end of the leash and then say, oh my God, I didn't realize that last $20 contribution put us over the threshold, and now I've got to do reporting requirements from 3 reports back. And so I would be more concerned about setting up citizen groups, non-professionals as it were, to fail, by thinking, oh, we don't have to file, we got this $5,000 limit. And so as I understand it, 200 was ruled unconstitutional as too low a threshold. Our Secretary of State has issued a $5,000 threshold. Citizen groups have already sued to say that threshold is too high. And, I can understand in a big city, you may not be able to do much with $5,000. In a small community, could be a wash of money, for advertising. And to me, it's more about the public having the right to know who is behind any given issue, whether he's supporting or opposing, but just a right to know, well, this one's being supported by this citizens group or this special interest group or these 10 special interest groups, whatever. Just a right to know. And then that may influence your decision. Was it out-of-state money? Was it corporate? Where'd the money come from? So I do think that would be something we need to discuss pretty thoroughly going into the ordinance. I think the happy medium is somewhere in between. I think there was a new report that Scott Gessler released that was just published in the Pueblo Chieftain yesterday as well, about who makes the most mistakes. And it seemed that the small issue committees make the most mistakes in their filing as opposed to the big boys who hire professional campaign managers, professional accountants, and things like that. I don't think the magnitude of the mistakes was as big, and generally not much fine, but was interesting background information. So I'm willing to myself say I think somewhere in between, and I'll take the advice of the attorney and everything if we have to have a threshold of some sort. But I think it should be, like 1,000, just 10 times what was ruled unconstitutional, 1/5 of the other. It's a nice even number. It's twice the individual campaign contribution limit that Jack was talking about. But we'll have to test the waters with those things, and it's not very likely we're really going to have something passed for this fall,
Correct.
time-wise, just between first reading, second reading, determining. But, again, I think that any issue committee that's out there is just going to have better faith with the public by disclosing everything and by starting from day one with everything reported, so you don't have to play catch-up 2 months down the line in the heat of the final filings.
The other thing I might suggest is, first of all, there is no clear guidance on what the magic number is.
Yep.
And the magic number for the state of Colorado may not be the magic number for Pitkin County,
That's right.
although it has always applied at all levels of government, that particular disclosure threshold. I do think that it's perfectly appropriate and probably a really good idea when we get to the ordinance and the public comment, ascertain as best you can kind of the sense of the community on that particular issue. What's the magic number that we think in this community is appropriate?
Yeah.
Because that is a very important question in cases that challenge these things. Courts take a dim view of legislators picking a number out of the air, and I believe courts give more deference to, a
So
robust
community
public
center.
hearing and community center.
Yeah, that makes sense. Did anyone else want to weigh in on that issue? Rob?
That, but it touches on one other thing, but this is where I think things should be in our home rule charter versus in an ordinance. And, I would, in the language that you have, the start of the language in section 4 here of this ordinance, I would, instead of saying, these are the limits, I would refer to our home rule charter for the limits as opposed, I know that the home rule charter trumps this, but this is one step closer of eliminating our home rule charter
Charter
because
doesn't have limits, that's the thing.
well, for that particular one, but it does also for the $500.
Yeah.
You've got in 4.2, $500 per primary general election. I wouldn't even use that language. I would say per the regulations in our home rule charter.
Well, there's clarification of the home rule charter that needs to occur in that regard.
Yeah, understood.
Okay.
But my point is I think those sorts of things, as you said, we need to get the public to weigh in on these things. These are the types of things that I feel, from a philosophical point of view, should be in our home rule charter and should be decided upon by our voters, not necessarily decided upon through the board.
I understand, and this outline was not, the ordinance obviously has to give enormous deference to the provisions of the charter. And if there are areas where you have to deviate from the strict language of the charter, that deviation is necessary because the legal landscape at the time the charter was adopted has changed so substantially until now. I think it's justifiable to do it by ordinance, but I agree with you that you want to clearly say where this is coming from and why and so forth.
Jack?
On that item, in almost this bigger picture, I'm not convinced that what happens today, Rob, you're looking at going to amend the charter in the before the 2012. No?
No. Eventually,
Oh, okay, good.
doing something to the charter.
What we're faced
No.
with today is
No.
the question of the ordinance.
And that, my main decision for that is that the Secretary of State has not weighed in a timely fashion, allowing us to make the proper amendments to the charter. I mean, if we do an amendment and it doesn't agree with the Secretary of State, then we have to re-amend the charter again.
And I thought the pressure point was for this year, where that's off the table, we're not going to deal with it. But for 12, there was an intention, but maybe not, and we'll think about that later. But what's before us now?
If it was 2012, it would be on the ballot in 2012 to affect 13. So there's
Yeah.
going to be no charter change or even question about the charter
There's gotta be a
until
question
2012. And that was what we decided earlier in this discussion, that we'll just go with an ordinance now.
Yeah.
So anyway, we ought to focus on this, and I would take both Dwight's suggestion and yours, check in with John, and let's move forward. So the question is, what is the timing of the ordinance realistically? How, within the next month, we could have a reading, or?
I would expect the beginning of 2012.
Between budget hearings and everything this fall and other business, every single one of these bullet points in this intro is going to be discussed as part of an ordinance and needs to be fleshed out. That's my understanding. It's not just a small ping. It's big.
What I don't understand then is, okay, we're stuck between, all in or all out. I thought we needed to do this before, and enough in order to have public process, etc., early enough to be prepared to have some direction for people even in the 2011 election.
Yep.
So we're just going to be stuck in limbo until, at the convenience of the Secretary of State, they'll give us an opinion. I thought the reason why we're doing this is so we go and have something on the books this year.
Do you want me to take a crack at
Well,
this?
I'll try. We don't have a chance to have something realistically on the books for this year. Dwight kind of started his comments with that by saying that it's been the tradition for people to file, the local parties have said they're going to file, and as far as we know, any issue committee that's moving forward on any Pekin County ballot questions is intending to file and do full disclosure. But that we would like to have something in place by ordinance for 2012's election, for both candidates and issues committees, clarified by ordinance the next election cycle. That this election cycle has literally already started, and the election is less than 90 days away. So any ordinance that we were to have first reading on, second reading, and then taking effect 30 days after the final reading would put you maybe a week before the election or something. Time-wise, it's passed.
Well, I thought this was, excuse me, John, I thought this was really prepared and ready, just about to go, except for an exact format. Now, I think we're making this way complicated. I think that this ordinance is ready to be, have some more work on and prepared and passed. It's an ordinance. It's not home rule charter. It's not a charter committee. And certainly the board, or at least what I'm hearing right now, at least the staff's recommendation and the board are not on board, are not consistent with my thinking, but I think we've made this way complex. The way I understand it is we're going to literally write what we think ought to be, and by ordinance, if we have to, we get a decision, we might change something, but I don't see any reason why not have this on the books within a month. And honestly, I'd have to look at calendars, and so I could be wrong in a month. But you're right, it is less than 90 days.
Yeah. George or John?
Yeah, I don't want us to push forward on an ordinance until we actually are able to drill down what we're going to hear back from the state, and that may take a month, it may take 2 months, and how that's going to impact not only us, but the city and county of Denver. So this is not a sense of urgency in terms of having to have something done by the 2011 election. It's really going to determine how we're going to go forward in 2012, and that's why we discussed that probably starting January 2012, we will revisit this, see what new information has come about, and make some decisions then.
Yeah, I agree with that. I mean, literally, if we were going to have a ballot question to change the charter, it would not be in effect for the 2011 election cycle. You know, if we had a ballot question.
Charter's out.
Right, I know, but if we weren't going to affect this election now, is all I'm saying. So to say we have to rush an ordinance to have it in effect for this election now, when, you know, even in the previous past would have not had an effect. And I think that there are some really pretty substantial issues that have been raised. And to my mind, this is what happens when you hire a diligent professional to be the elections manager who has determined that our charter, which has not been updated on election finance issues for decades, is totally out of sync with what has been occurring at the state legislature and federal constitutional changes, you know, and we just haven't done any updating. But, you know, some of these questions, you know, who determines whether a candidate knowingly violated a provision of the Home Rule Charter? Is it the county attorney? Is it an outside attorney hired by the clerk's office? How do we administer any of these things? And what does knowingly mean, knowingly misconduct? Is it, you know, what was that? I mean, there's a lot of different, most instances of noncompliance are unintentional omissions. And you're going to have to set up who's going to be determining was it unintentional omission or an intentional omission. And you know, we've been told there's maybe some cost associated at a greater level. I mean, last year was the first time we had a write-in candidate, which changed, you know, significantly the clerk's burden. So, you know, yes, some things are very simple, just clarifying when you have to live in your district and how long you've had to live in your district. Other things are not so simple, and I think we'll just move forward as quickly as we can, but this really does point out we've just, you know, it's kind of like not updating how you run your engines, and all of a sudden everybody else is out there doing hybrids and electrics, and we're still on a very old two-stroke. So we need to work a little faster on this. You know, I think another issue that's been raised, at least to my mind, and I saw it in the city election this past time, was, you know, well, $20 is the reporting limit, so we'll get $19.99 from hundreds of people. And is that the intent of the law? And you know, do we want to have, you know, there be any threshold for non-reporting of who's contributing, and is that, you know, what is the transparency that the public expects and demands from us? So, A, I don't see anything way to rush this. B, it still has to be on a front burner, or we're going to start bumping into problems with timelines even for 2012. But the direction seemed to be to move forward with an ordinance, not a charter change question this November.
As far as the timing goes, and John are much more familiar with your upcoming workload and calendar than I am, my preference would be to have an ordinance adopted prior to January 1, 2012. And I know there's a lot of budget and other issues that you need to address. And I say that only because we've been looking closely at the election calendar for next year in the cycle, and it literally begins in January.
Yeah, I mean, once someone has publicly declared their intent to run, they need to file their paperwork with you pretty quickly, within 10 days. I mean, there's certain rules like that, but I know that the two parties start to have meetings in December
Right.
to say, well, who's thinking of running, who's thinking of running. So it does start very early on. And, you know, I would think that the suggestion would be to start writing the ordinance as clearly as possible, pull out the decision points along the way that are going to need specific board input. Maybe we'll have to look at a 2 or 3 hour single work session topic and try to just cut through that as quickly as possible, so it's not in these little teeny chunks.
Sure.
So I think you can go ahead and start the work, and as you said, John can start the scheduling issues and review issues so that we can get this on track.
Okay.
Are there other discussion points or anything that...
Just a real quick comment. I was under the impression that a decision from the Secretary of State was imminent, so to me, that was kind of driving. And with an unknown, yeah, and hey, I'm okay. I mean, whenever we get to it, we get to it. I see no further reason to have any more discussion on this, except direct that we move forward.
Yeah, and once we have the ordinance ready to start reviewing, to start public hearings.
Right. Okay, very good.
Other comments? Did I miss anybody else on anything else? Okay, no, well then we will adjourn this item, and we will go ahead and take our lunch break and meet back here at 1:30. We've got a few extra
Do
minutes.
we want to do that? I mean,
You know, Jack,
I don't mind just saying, discontinue the special meeting, whatever you call it.
My feeling is I don't really think we're going to have enough time to jump into it for less than 15 minutes to when we're supposed to take our break. I'd like to...
So should we do a formal action, John, by suspending it or
Well, we can see
handle
how...
the special meeting?
If you want to make that decision.
So it's up to the chair. Where are we at?
I think we need more real time on that topic, and we already kind of gave our general comments for the things we'd like to have answered or how to set it up for a real thorough look. So I would entertain a motion to adjourn the special meeting.
So moved. Second.
All in favor?
Aye.
Okay, so we will discuss that another time, and we will break for lunch, and we will meet back here at 1:30. County work session of Tuesday, August 9th. It's about 1:30 in the afternoon. Our next item on our agenda is the pig iron septic and water system issues discussion. John Redmond, you're going to lead it off for us, and then just everyone please introduce yourselves for the camera, for Grassroots TV and for the record.
Okay, I'm John Redmond, Finance Director.
Ted Schuster, the President of the Homeowners Association.
Debbie Ware, I'm the Treasurer of the Homeowners Association.
Thank you.
We came to you in February. A request has been made at that time related to the expenses for the replacement of a leach field and the potential for some additional leach fields that needed to be replaced, potentially needed to be replaced. There were some historical costs due to litigation around the hardness of the water and the water supply. I believe at that time the board was not interested in participating in any reimbursement on that level. I think at the time what I was hearing was there was some concern about the HOA and the long-term sustainability of the HOA. They had a cash flow statement which went over a number of years and showed a rather large negative balance. At that meeting in February, a very large request was made, which I think was soundly rejected. And so we went back and looked at the potential expenses and tried to determine what would help the HOA in the long term. I do not believe that the board was in any way implying that there was an obligation, but there was some concern about the sustainability of the HOA and whether we could participate in that. So we have made a recommendation. The recommendation is to reimburse them for approximately $30,000 for the actual replacement costs on the first leach field, which they did in 2004 or 5, and that some $63,000 be made available in the event that 2 other leach fields that could potentially fail in the future be available. So overall, it's kind of a $30,000 request at this point and a potential for $60,000 more in the future.
John, I know we have discussed this at one form or another since Dorothea was on the board and Patty. So prior to George getting on here, about 2.5 years. I was under the impression at one point in time that it was, a little more imminent to go ahead and replace those other 2 leach fields, and that the type of quote and price that we received was really based on doing 2 at the same time and, kind of in today's market quotes as opposed to waiting and doing 1 at a time or, seeing where the market lies in a few years. I mean, how stable are those 2 leach fields?
Well, I've heard indirectly from environmental health that there doesn't seem to be an issue with them right now. Ted, you live there, so.
I mean, I just don't know. I mean, some days I go out and I can smell sewage, and I don't know what that means. And there are viewports where the water's not supposed to be, and it's almost to the top. I go out there another time, it seems to be okay. So I don't know what's actually happening under the ground. But you're right. I mean, it could need to be fixed in the spring. It could last for a couple more. I just don't know.
Yeah, because
but it has lasted several years longer than when they first examined them, and they gave some pretty dire warnings. They've lasted longer than I had expected. So I don't know.
But again, you don't want to get to the middle of a winter and have a failure at a time when you can't
I think
replace.
those are pretty good. Yeah, because then you get to the point where they probably can't replace until the spring. So.
Ted, would you like to make any comments to us? And then, Michael, you have a question for John Redmond? Or?
Well, it's a question on the septic.
Okay, if you'd like to go with your question.
So the septic field, or the one that you replaced, failed because there was an incrustation of salts from the softening system that you put in. Is that right?
Yes. I think they think that was the cause. I don't think they could decide whether it was mineral hardness or the salt, probably a combination of the two.
Combination of the water that you were
Yeah.
dealing with and
Yeah.
then the remedy that you sought for the water.
Because it was, when that one failed, that was probably four years in, and we didn't have this water softener for very long. So I think it's probably a combination of the two, but I don't know if it's, I don't know what percentage.
Right. So so you're softening the water currently, is that
No.
right? You're not
There
softening
was
the water.
when
So, that's right. Then we went through the process
Right, and so the new
of seeking
water-
another source
right.
for your water.
So which I think has helped the leach fields. I mean, I think that some of the engineers have said there was a flushing effect on it, but to determine the long-term extent of the damage was impossible without digging them up.
Right.
But I'd rather not dig it up if it's not broken.
Right.
But then when it's broken, it's this weird thing. I can't really tell, or no one can really tell until.
So there's a possibility that
I think you start to tell when you start to get the effluence comes to the surface and it becomes like a swampy,
right.
and so that's
That's the
and that's
scientific
what happened to the
method
first
of-
one.
of-
Yeah, but which worries me when I start to smell sewage. Like,
Although it's not unusual to smell sewage from a septic system because
Right.
it's just not unusual. So now that we have a new water source, and that's much better water, and
Yeah.
with less of the minerals and no softening going on.
yeah, it's. I mean, I actually drink the tap water now. I used to I couldn't even.
Right. You wouldn't consider it.
I wouldn't.
So the prognosis then is that the life of the septic field, say replaced or the one you replaced, is indefinite or 30 years or something like that now. Is
Yeah,
that right?
yeah. So that one's. I don't think anyone worries about that one.
Okay.
That one's never seen any type of tainted water
Okay.
go through it. So.
Okay. I just wanted to find that out.
Yeah.
So. Okay.
Thank you. If you, again, want to make any comments before board discussion, we do have a memo on it, we've taken a look and
I don't
see where everybody lies.
I wasn't really. If you have any questions on it?
What are the homeowners dues for the different size units now? We just have the cost, we don't have,
Okay, so for a two-bedroom unit, right, or a one-bedroom unit, I'm sorry, it's $257.03. For a two-bedroom unit, it's $340.76. The three-bedroom units are $402.16, and the four-bedroom is $425.76.
okay. And then, what is included in your homeowners dues?
It includes insurance and, board insurance as well. It includes maintenance of all the common area maintenance and water system and the testing and all that goes with that. It includes plowing
Trash
and
removal,
trash
plowing,
and its heat.
The gas is the big ticket.
Yeah, there's a single boiler system in each building that does the whole building, so the association pays for that. And lawn maintenance.
Okay, thank you. Well, board, do we have any additional questions before we begin discussion of the staff recommendation? Rob?
Yeah, and it's regarding some of these finances. Because I don't know how many 2 bedrooms, 3 bedrooms, 1 bedroom, there are. With these current homeowners association, what is your cash flow projections, separating out the leach field stuff? What are your cash flow?
If we take all of that out, we're okay for the moment.
Define okay.
We have enough to pay the bills.
To cover your bills.
To cover our bills.
So you're not
We have
building
not had
any reserve with those
correct.
dues?
That's correct. So we have not had an increase in assessments in a couple of years, but we've been sort of holding off, trying to figure out, when we go to our homeowners and say, this is the situation we're in, we kind of wanted to see if we could get this out of the way, so we would have a picture of, yes, we can, we will have the money to pay off the remaining costs of replacing that leach field, or no, we won't, because if we're going forward with those costs paid off versus those costs not being paid off, obviously that makes a difference about how much money we need to budget and what kind of an increase we would need.
We also would start to address the debt we have with our attorneys and with our Schmeiser, Gordon, Meyer engineers. So, because those are sort of drains on our monthly dues. If we can eliminate those from that, then we can put the other monies possibly towards a capital reserve at some point. So that's kind of our next goal. Is once we have some the leach fields, we can deal with this $60,000 in debt for other stuff.
So just to try to clarify here, your forward-looking profit and loss statement for the HOA Association is a net zero, meaning your revenues match your expenses. Does that include your interest on your legal fees? Does it? Are you separating that out as well? So you're actually
separating it all out.
You're separating that out. So you're collecting a revenue that meets the bare minimum of your homeowners association's expenditures.
Well, do you think at some point, after we have dealt with engineers and attorneys, that there would be a surplus?
No.
Really? Okay.
Not at these rates.
No.
Okay.
I think that,
I
think
we
without
might.
question, we need to have some kind of an increase, but we have a couple of homeowners who are grossly behind in their payments to us, and we put liens on their property and all those things that you're supposed to do, and we get no. I don't know where we go from there, but that's 2 units, and then we have people who are not working or barely employed, so raising the rates for some people is not going to, we have to be very sensitive, obviously, about what we're doing, because there's no one out there who has lots of money.
It's hard to say, we're going to have a $5,000 assessment. It may come to that, it may have to, but it's hard for somebody that's...
Let me ask a couple more questions. And John, I'm not sure if we've had a chance to research this, but when the original pick and iron purchase was made, the county expended I'm not sure, was there a couple $1 million, $1.9 million, something like that. And then when this public-private partnership was formed to build these units and to allow the developer of the lots on the Woody Creek side to sell, to finance paying for the units, what was the revenue the county received back from the sale of the property?
Well, to the best of my knowledge, it was a straight, we purchased a property for X, we held it for a certain period of time, and we sold it for that same amount of money. So, if anything, there was a loss on the carrying of the...
On the carrying of it.
It was 6 years they carried it, so, there's substantial loss.
Right.
Yeah.
That's when the interest rates were real.
Yeah, and I was just trying to think. And then, so the revenues from that were taken back into the county and then rolled over into the Stillwater project?
Well, they were put back into the fund.
Okay.
And then subsequently, Stillwater was a project, but I don't believe there was any direct.
Yeah, but it was the next project that
Correct.
the county did. Yeah, I mean, because I just remember I was actually on the housing board, and it was before coming to the county commission, or excuse me, to the city council, and so that was like 90 when that was first purchased, the pick and iron site. So I think it was more than 6 years, but I'm not sure when the development began with the county. It was a long time that it just kind of laid idle. And that was the way the county structured it, was that they get these units plus the cash back, and we'd go from there. Okay.
Well,
Michael?
they actually put an RFP out for development projects.
Yeah.
And the project that came back in, Tim Semrau's project, had essentially the highest ratio of affordable housing to private housing, and had the least kind of impacts. Other people had much higher densities, and it was decided that this was a good ratio.
Yeah, that was preferred project that was selected by the county at that time. Okay, did I see other hands go up? Jeff?
Yeah, this, obviously, it's a challenge for all of us, whether we live in free market or housing. I've lived in my unit with my wife for 27 years. I'm very aware of how HOAs, affordable housing, HOAs especially, should run, since I was about the president for about 25 years. And so I can understand the challenges about finances, whether it's in a good or bad economy. But when I look at what your assessments are, and I have the paperwork that you submitted, Ted, and back in, I guess the date here is '09, but I have paperwork from '08. When I look at this, I think the county has substantially helped you all out with trying to resolve the water problem. Thank goodness. I mean, that seems to be a real had been the original challenge about the quality of water. And then my memory tells me that, and the feedback we've gotten from you, is that as time went on, you tried to address it, and you had a water softening company come in. They recommended a mitigation, and you approved that as an association and installed that. And then the resulting problem appears to be the leach field thing in some connection.
The water softener was the suggestion of Simmerau and the builders as a remedy, as a less expensive remedy than finding a brand new water source. So, I think at that point as an HOA, we decided, well, that was, okay, if that's a possible remedy, I think this man has more expertise than I will trust his judgment, which was unfortunate. But I think that to say that the HOA chose that by itself is not accurate.
Well, I didn't say by itself. It's all a series of events that lead to one place, you being here today.
Right, but you trust the expertise of people sometimes.
Well, I'm not going to sit here and have any kind of a discussion about whose expertise is what. When we, as my association, made decisions, we made decisions, and we moved with them. And, we had an analogous, but not similar. Our project was built in 1980. Within 11 years, we needed a new roof. Roofs are supposed to last 20, 25 years. So, where do you draw the line, and who? Well, are we going to go to the town and say, we need you to help us pay for a new roof? I don't think so. That didn't work. I mean, that never came up because we felt it was our obligation. We signed on the line. Now, a question for you all. What options have you looked at in order to deal with the financial challenges related to this, other than coming to Picken County?
Well, this has been our focus because it has not been resolved and been able to be resolved in 2 years. And so if this is not something, then we're going to have to figure out how to continue to muddle through or try and get some kind of a loan or something like that, which we may or may not be able to do. But the bad water in the well was not. I'm not sure that's an everyday occurrence in construction or in homeowners associations. I'm guessing it might not ever happen like that again.
Yeah, well, it's unfortunate, but the project got approved and certified, and whatever the steps were, I wasn't on the board, so I'm not sure exactly what the code was then. But I'm real concerned about the large recommendation by our staff. I see no justification for it, John. Why would you make this recommendation in two parts? Well, 2,000 and 63,000.
Well, it was my belief that, in previous discussions, that the county was willing to look at something. And so my first thought was, well, let's look at the existing leach field, which has been replaced. I didn't think that was an unreasonable objective, was to reimburse them for costs. It would help them to maybe defer some of the existing costs that they have and maybe buy down some of the debt that they've got. And in terms of the other two pits, really all we're doing is we're recommending that money be set out there in the event that it fails. And right now it appears that it's doing nothing but getting better. So that's, although it's a pending commitment, I think the chances of it happening seem to be less and less as we go further and further down the road.
Well,
thank you.
If I could add on.
Please.
To that also, Jack. The question, as we understood it, that we were asked last time we got together, was trying to nail down a number that we thought would make the homeowners association sustainable, obviously with some tough decisions still on their part, and not taking responsibility also for some of the decisions like litigation in the process. And so based on the information that we had through our discussions with the homeowners association, and some of those parameters we understood from our last discussion, that's how we backed into this number and how we backed into looking at the physical infrastructure on the leach field. In no way is staff making a statement about whether the county has an obligation or not. This is our recommendation based on what we understood the question was to us last time, which is, what's that minimum number? Because I think we started with a request at the $182,000 number. Then we had a request at $135,000, and we were trying to figure out, so what is that number if we're not going to take responsibility, we're going to have a viable housing project in HOA in the future, what's that minimum number? And based on the information we had, this is what we backed into.
Yeah. Rachel, may I continue?
Yeah, please.
Thanks for the explanations. This is very troublesome because staff uses the word viable or sustainable, association, etc. When I look at the work that was done through the capital reserve studies promoted by and supported by Frontiers and this board, there are thousands of dollars out there of work to be done by associations. Does that mean that the associations line up at our door and come in and ask us for money, each of them? I hope not. So, though this is unique in that, you're right, I've in my time, and I've been here 39 years, I've not known of a water problem like this. I'm having a very difficult time drawing the line in the sand and saying, well, should we or shouldn't we? And then a number comes before then. So I'm not even there. And for me, looking back at the memos we had in the past, at least this says assessments have not been raised since 1107. I think my assessments have gone up maybe twice since then. And we don't have any problems except normal capital like everyone should keep up their buildings. So, it's a real concern coming to the county here, and so I wish you could have come in here with a plan about assessments, knowledge about a loan, or, well, what would it take to add some, because in my notes I've seen we discussed this, maybe add some piece of this to the sale price to, reduce the impact, etc. That's in part. I mean, I'm not saying the next guy should pay for it all. That's not right either. But just to try to, pass it on down the way. So I'm certainly interested in hearing more from the board, the BOCC board, as to where we might go with this. I've expressed real concern about heading down this road. This is an unending road.
Michael?
I can understand Jack's concerns. And, Jack's fortunate because he was able to get into a housing project that was free of problems. Relatively. And so I don't think that really bears comparison to this project, which was, the nature of this project was that it was an experiment by Picken County. It was a private-public partnership. We had the land, Tim Semmerall had the expertise, and he had a very good design. And to a large degree, the project is really wonderful. I think there's much higher qualities there than you'll find in other projects. The fault was, and it started with, the water supply, which wasn't, it's hard to really, you can actually visualize how bad the water supply is if you imagine painting the inside of your dishwasher brown. That's what it did to appliances and to sinks. It was horrible. So it's not just sort of a water problem. It's like it shuts down the whole place. At which point, the developer was reluctant to do anything. Really reluctant. And I think the lesson for Picken County is that if you enter into a partnership, you have to make sure that the performance and the circumstances are covered, whatever they might be. And we just didn't have that kind of contract, essentially. And we've learned from that. And this is part of the learning process. I mean, and then, like all mishaps, it's not one thing. It's not just the O-rings. It's the temperature. And it's the decision made by a group of experts that shouldn't have been made, and so forth and so on. And it accumulates over a period of time, and it exacerbates itself. So that's why we find ourselves in this situation. And I'm reluctant to blame the homeowners for their fees that they're charging their fellow occupants, because they're in a very tough position. It's just very hard to do. And then you crash that sort of personal disaster into the disaster that we are all suffering, which is the economy. And that's a tough deal. And I haven't heard that they don't want to work themselves out of that position. They're just in a tough place. So I'm much less troubled by the use of these funds to help them, because in effect we failed. I think we failed to make sure that the contractor would perform. Who would think to put in the contract that you will supply water that won't turn your appliances brown? It turns out that it was potable water under state regulations. But when it dyes your appliances brown, you're kind of reluctant to drink it. So the contractor essentially walked away. So that's something we've learned. The public-private partnerships that are talked about a lot, they're not the answer necessarily if every party isn't satisfied. If one party can walk away without fulfilling what we would consider quality of life obligations to the people who we built for. So I'm much less reluctant to spend $30,000 to reimburse for the existing leach field, and I'm willing to do it on if it's possible, feasible. Now, if there is a failure in midwinter and it can't be shunted to the other leach fields for the course of the winter, then we have to think about that. But I'm not sure how it's wired or how it's plumbed. So I just don't know. So if it's plumbed that if one unit fails and there's a redundancy in the other units, then you're fine. But if it's not, then you have to deal with it.
They're separate.
They're totally separate. Pardon me.
Then we have to talk about that. So then we have to do some risk assessment, it seems to me. But I'm much less. This is such a unique opportunity, I mean, not an opportunity, but such a unique circumstance, both for Picken County and for the homeowners. I think we have to look at it with a very open mind.
George, do you have any?
Yeah, a couple of comments. First, I'm really disappointed that the homeowners association has not gotten together to address this problem since last February. In essence, you've waited to come to us again without actually having had a thorough discussion. Some of the points that Jack has mentioned. This is really your homes, your problem, and for you to continue to avoid that discussion with your homeowners, I think is a disservice, certainly to the county here in terms of now coming and trying to put the entire impetus onto us. So I have a problem with that to begin with. Now, having said that, I believe that we want to try to help employee housing units to continue to be able to provide affordable housing for our workers. And although I do not agree with the final amount that this board supported for the Woody Creek HOA under different circumstances, I was at some level in terms of supporting their efforts to keep that HOA from going under and displacing employees. And at that point, I said that I felt that there needs to be responsibility from the homeowners to be able to share in the cost of continuing to be able to sustain that HOA at Woody Creek. And I think the board decided at the end that it was worth going the extra dollars because it was too important of an HOA, too important for employee housing to go under. So in the similar case, there's some merit to your needs. I could be supportive of looking at replacing the original leach field that failed early on. That was a problem that even though it was precipitated by a contractor, and unfortunately the contractor walked, not necessarily means that the public sector has to pick that cost up. But because it's an employee housing HOA, I think it's important for us to try to support a situation like this. In terms of the other leach fields, what you're asking for is, in case they fail down the road, the county should be able to set aside some funds to help. I have a problem with that. Similar to other deed-restricted employee housing HOAs, they could each come in and say, well, you know, I think our roof may fail in the next 10 years, or I think we're going to need to replace our siding, or we're going to need to do this, we're going to need to do that. That's where the HOAs need to set up a capital reserve to look at future needs. It is a burden for the existing homeowners. I understand that. I understand the nature of the economy. In my neighborhood, which is fairly small, the last year there have been 6 homes that have gone under foreclosure and a short sale due to a variety of reasons. So it's not an isolated case. And I'm ready to help out and assist the HOA with some of their costs, certainly with the initial leach field in terms of replacing that. But I think the impetus after that falls back on the HOA to look at coming up with a long-range plan to fulfill that capital reserve, not only for future needs, future leach field needs, but any and every other need that you cannot anticipate, but that will occur over the course of 30 years. And so that's where I'm at for right now.
I when you suggested having a fund for the remaining 2 leach fields, I don't think you were suggesting that the fund remains sort of there in perpetuity. I mean, was there a time frame? I mean, like say.
I didn't suggest that. So.
Well, yeah, I guess what I would suggest is like, there's a natural life to something like that, and maybe.
Well,
John?
if I could, George, I think the information that we're working with was that your engineer had indicated that they'd have to be replaced within a year. Now, obviously, I think
Yeah, it's been.
there's some wiggle room on either side of that, but I think it would be within some time constraint as determined, but we don't have that in the recommendation because it's hard right now to pin down that number, and we weren't completely clear where the board's policy discussion was going to go on how to provide assistance or if to provide assistance.
Okay, thanks for that clarification. So it wasn't considered to be in perpetuity, but was more that the original indications were that this leach field would need to be replaced. We're not thinking that it's going to last.
Well, and I think as an HOA, we're like, well, if it had to be replaced tomorrow, and we would crush us. But if it was 10 years, it would buy us some time to get our house in order a little much,
Yeah, what I'm suggesting is, again, I understand that your dues really just cover your basics now, and you don't have the ability to put any dollars into a capital reserve.
And I think our dues are going to be raised at some point.
And so to anticipate not only, again, a future replacement of leach fields, but you have to figure in a future replacement of roofing, of any number of things that come.
But we're trying to get out of the legal fees.
No, I understand that.
So our vision is still, it's going to be a decade down the road. It's a decade in the making. It's going to take a decade to fix it. So.
Rob?
First of all, I do believe that with all employee housings, there is a partnership between the housing authority, whether it be the county, city, and the tenants there. And the partnership is really a two-way street. I think the ideal scenario, my understanding of the employee housing program, is that we pass off these obligations to the HOAs, and the HOAs act responsibly. For the county to get involved in a day-to-day management of an HOA, I think, is where a program kind of fails. We don't have the resources to do that, so we give the tenants the obligation of upkeeping that side of the bargain. When I moved into my employee housing unit, I didn't know that 4 years down the road I'd have to pay $7,000 for my portion of a new roof, which is what happened. No idea. It happened.
Was the roof defective?
The thought process that I have here is that I want to make sure that if there is, I think we're looking at this to some aspect as a handout. We don't feel we have a legal obligation here. If there is that, what sort of reassurances are we going to get that things are being managed properly without us managing them? I think since our meeting in whenever it was, January, February, the dues should have already been raised. They should be raised tomorrow in my mind. Just because someone can't pay the dues, it doesn't mean that you as an association don't project and see the obligations that you're going to have in the future, whether they be these leach fields or some other capital maintenance type plan. I'm not sure what the deed restrictions are on these, but I know as homeowner associations in employee housings are going through various things, they're updating their deed restrictions to the most current deed restrictions. It's another route that I would take. I don't know if you guys are getting, if it's an older deed restriction and you guys get straight 4% on your appreciation, now that's no longer the case in employee housing, those
No.
sorts of things.
I think this was a project.
To make sure that the regulations are up to 100%. I'd hope that you're doing things like collecting interest on past due balances, because that means that those tenants are on the hook because their asset is diminishing. It's a negative item that goes against the property value if they do have any money in their property at this point. So in essence, you are getting a revenue from the interest from those things. These are the types of things that I don't really want to have to manage for an HOA, especially as a board, and nor do I think it should be the responsibility of our housing authority. I do think we have an obligation to keep affordable housing affordable. I think I've been asking John, our county manager, every week, when is this coming back up? When is this coming back up? And it kind of got moved and moved and moved. And now we're coming to this meeting without really a game plan from the homeowners association, other than, we were waiting to see what the county would say. I mean, I'd like to see what your plan is if we gave you $10,000. I'd like to know what your plan is if we gave you $30,000. I'd like to know what your plan is if we gave you $60,000, or if we gave you the full recommendation here of $93,000. I mean, what are your game plans when those scenarios happen? I think we have an obligation to keep affordable housing affordable. But defining what that means is very challenging with the information that we have in front of us, in my opinion.
Thank you. Jack, and then Michael, and then I'd like to make a comment.
Yeah, Rob, I think an answer to the question, keep affordable housing affordable, that's clearly the deed restriction. Regardless if it's a private-public partnership or the public sector builds, sells, etc., ultimately the deed restriction determines really what goes on and how it remains affordable. And it's pretty ironic that our staff even suggested the total number of $93,000, but there's $13,000 here that was for litigation. So why wasn't that subtracted from Smeezer Gordon Myers? I'm just. It's just a shame that this is before us. I might be inclined to go with George's recommendation in that recognizing the challenge, there's just no way legals or, I'd be involved in any help in any way, shape, or form, including that 13. But I think I just, in attempting to reach out, I would agree with what I think George said. That's how I should state it, the $30,804.84. But what is in the future has just got to be the association's own challenge.
Yeah. Michael?
Yeah, I think the conversation's gotten off track because essentially you're holding the homeowners responsible on some kind of homeowners dues accountability, and that's really not the question here. If you'd want to hold people accountable, if you really wanted to hold somebody accountable, we would have held the developer accountable, and we would have made sure that he couldn't have gotten away with this nonsense. These people, in effect, what you're doing is blaming the victim for not being diligent about where they walk at night after they've been mugged. Because this was essentially a mugging by the developer. I think the homeowners here are going to be responsible homeowners. There's nothing to indicate that they're not responsible homeowners. So you're blaming them for the fault of a developer who leaves them with inadequate water, defective leach fields, and lawsuits. And you're saying, well, that's your problem. The fact of the matter is Pickens County's problem for partnering with a guy like that. And quite frankly, it wasn't taken care of by previous boards. So to hold them accountable for their homeowners' dues, that's the basis of the problem, that's ridiculous. The basis of the problem is the poor construction and poor management by the constructor of this project. And unfortunately, it's a very unfortunate situation. It's not something I like to do. But given those circumstances, I think we are obligated to help them.
You know, please, we appreciate that, but can't do that. I want to weigh in. We've discussed this a little bit, and you know, as I said at the beginning, I've seen this since Dorothea Ferris was on the board, and almost, you know, and it's come back, and we really haven't taken action. We've sent them back for a little more of this information, a little more of that information, hesitancy. You know, I've heard the same comments, Jack, from you for a long time about the same issue, and you probably heard my comments the same time. But I do think this was a public-private partnership. And everyone likes to think that you get into a public-private partnership and all the responsibility will be on the private side, and the public just gets to be at the ribbon cutting and say what a great job we did with affordable housing. But sometimes there are lingering problems, and it's unfortunate. And I think Michael's right in that there has been a lot of learning experience about HOAs. You know, just a lot. I think that, you know, we haven't required whether it's set up by a private developer as part of a private mitigation or public-private partnership or a totally public project, that there needs to be minimum balances from the very get-go in these things, that there needs to be a schedule for rebuilding up to that minimum balance once expenditures have been made, that there be some sort of pro forma of, you know, how much goes into the capital reserve above and beyond the trash collection and heat and things like that. And so I think there's been a lot of learning experiences, but I'm sitting here at the table looking, saying, well, we just scheduled a September 7th housing work session to discuss how best to spend and use and utilize our payment in lieu funds and our housing mitigation funds. And, you know, I'll be damned if I want to move forward on a single affordable housing purchase project or concept when we have lingering problems out there with the older ones. I don't want to put something for sale and say, well, you get the same guarantee that the guys over there picking iron got, that, you know, once the private sector fellows built it, we wash our hands of it, and if there ends up being defects in the project 3 years down the line that you couldn't have anticipated, well, you're on your own. I mean, when people buy into something that's new, totally new, you have some expectations that the septic tanks are going to work and that the water system's going to work, and those are basic things. And so, you know, maybe our tensions are getting higher at the table because we ourselves have let this linger on for longer and longer periods of time. But, you know, it's not just the deed restriction that makes a unit remain affordable. It is the monthly fees. It is your homeowners association fees. If we set something up and tell someone, well, you can buy in for only $100,000, $150,000, and at today's great interest rates, your monthly payment's going to be X, but your homeowners association dues are going to be twice that, we're going to end up with a project with foreclosures. You know, I think we're probably close to that already. People who just want to, you know, all around the country, people are walking away from mortgages on units that they can't afford, that they're underwater with. This is the equivalent of being subprime loan underwater. They're underwater on the expenses of a project that was defective to begin with. And, you know, I'm really kind of discouraged to see us latching on to the idea that maybe the other two leach fields won't fail. I mean, I don't want to replace them if not necessary, but from what I've heard from past meetings and going forward, we're just lucky they lasted this long, and we haven't been on a pumped sewage situation all winter long. And, you know, the water system, I want to make sure the homeowners association is investing their money and making sure it's fully insulated going across that bridge, and we don't have a freeze-up like we did this last winter when the homes were without water for a number of years. And, you know, we received back into our general fund or to our funds, I'm not sure which one, housing fund, general fund, the land sale from Centennial Lands, that was affordable housing lands, that there was a settlement of a lawsuit, as long as complicated, we all know that, but that was close to $1 million. And then we've received $1 million that was excess from the Midland Park Homeowners Association dues, not homeowner, but the mortgage, the bonding reserve, get that right. You know, that's significant money for affordable housing. I think we need to, do this once, do it right, have it done, not see you guys again, other than some commitments about what will be the future contributions to build up reserves to take care of all the expected and some unexpected routine maintenance of a property and replacement over time of those roofs, those boilers, driveway regrading, whatever it is, drainage. But, it's not going to be a pretty picture. Yet, the rules were passed by us with the city, with the housing guidelines not long ago, to allow the housing office to enter into the foreclosure process and to take over the foreclosure for homeowners associations who have liens, who have the grounds to do it. So what's the housing office going to do? Foreclose on the property and advertise it for sale and tell people, but by the way, there's an outstanding obligation of $60,000 or $160,000, and who's going to bid on those units? Who's going to buy those units? I don't know. If the original bank is not satisfied with their lien, they have an ability to lift the deed restriction. If a lender can't get 100% of their money out, they can lift the deed restriction on the resale of the units. And so, I don't want to see us slip down towards that scenario. I don't think there's a reason to. It's been said this was a decade in the making. And, the problems with the leach field were not immediately apparent when the county, subtly started investigating and talking about lawsuits against the developer on the water issue. And then he came forward with a better water proposal. But, it wasn't done right in the first place. We were a partner in how it was supposed to get done right. And I think we just need to take our bath and be done with it, I'd allocate the full amount, get the other two leach fields replaced, and pay off the first leach field. You will still have the obligation of paying off the legal fees. These guys pursued $60,000 worth of legal fees to try to get Culligan or someone else on the hook for the leach field. And it was at that board with Dorothea and others that we pulled back and said, no, we don't want to put our money towards litigation with an uncertain future, but maybe we can help with the leach field. And we just kind of, mutually led each other along without taking action. It was, we'll come back and just talk to us more friendly. It's not an obligation of ours, but maybe it is a way we assist our citizens. We're not going to do legal, but maybe we'll help with the leach field. And it's just been 2 years worth of uncertainty, and unnecessarily so. Again, $90,000, I look at it, it's not pretty to have to see it go towards this, but it's less than the cost of one new two-bedroom unit somewhere. And I'd rather make sure that the tenants and the citizens that we have are adequately and well taken care of now, and that those units are not lost to the affordable housing industry, than to leave that money in a bank account and then just casually proceed with creating more wonderful housing for people, ignoring the fact we've left some other citizens in the lurch. And so, that's where I'm at. I just think we need to do this full amount and be done with it. And get the other two beach fields replaced while it's still summer and we're not into a pumping sewage situation in the winter. George?
Michael, I'm not blaming the HOA at all. I'm saying I'm disappointed in the HOA that they haven't really sat down as a group and come up with some alternatives. It's unfortunate that the developer has put you in this situation, and despite all your best efforts in terms of pursuing legal options, that you have not been able to hold that developer accountable, and that's very unfortunate. I think that we could spend all of our housing money addressing needs of all of the HOA deed-restricted programs we have here. Many of them are 30 years old, and I'm sure they all have problems, and that's why many of them went through a capital reserve study to try to figure out how to address their future needs. So we could easily say, let's use all of our housing dollars and shore up our existing HOAs to ensure that they don't fail, and forget about building new ones. And I just don't think that is a reasonable approach. I think that there needs to be a shared cost, there needs to be a shared responsibility, and I think the county can and should assist at a certain level. I just do not agree with the level that Rachel suggests, and I did not agree with the board's ending point with the assistance to the Woody Creek. So there's just that difference there.
Yeah, no, and I'm not suggesting all HOAs. I think there's a real difference. I mean, I live in Hunter Creek. I know we're going to have a huge replacement cost at some point with the front windows. You know, they're 3 stories tall, all steel construction. No one makes them anymore. It was a project the county accepted as a conversion project when it got the Centennial land. God only knows how many years ago it was done. I've lived there since '88. That's a big outstanding expense. But the county didn't build that. The county didn't contract for it to be built. The county did contract for this to be built. I think it's a very unique, totally different circumstance, you know, and that's, you know, maybe why people want to not get involved in affordable housing and not do affordable housing. So I wasn't talking about assisting all HOAs, and I don't think we're setting ourselves up to do that. But we were involved in this. And I also think that, you know, the number I'm talking about is, I mean, we're down to this 135 here because the lawsuits are not even in here. But it still leaves them with a very large obligation with the lawsuit fees from their attorneys, either negotiate it out and get a settlement and get them to write it off as bad debt for you, you know, pay them 10 cents, 25 cents on the dollar, settle the lawsuit, outstanding fees somehow. But they still have to work on that. This isn't taking all the responsibility out, whether it's the fees for Gordon Meyer that were related to the lawsuit, as opposed to related to the actual engineering for the leach field replacement, and legal fees. It's still leaving them with half or close to half, maybe more than half, I'd have to do the math here, of the amount to cure the problem. We're putting in the money for the capital amount to cure the problem. They're paying off the amount that was related to the legal fees and engineering to have tried to steer themselves out of the morass. They were doing that. They were trying their best until they literally ran out of funds to continue the lawsuit. John, you have
I just want to be sure we're all clear on the numbers, because I know that's come up a few times, and maybe just a good place to make sure we're all clear on. The Homeowners Association spent $182,243.97, and that was between litigation and repair and replacement of the water system and the leach fields. That does not include the potential replacement of the 2 leach fields at $63,000. So if you take all of that, okay, you're really starting, you know, assuming that you have to replace those 2 leach fields, and I think that's a question at the table. But that's $245,243.97. Okay, so that's the total amount that's been spent, and that we understand may be a near-term future liability out there. $182,243.97 of that has been spent. $93,431 of that was spent on litigation. And John, does that include the $13,000, or is the $13,000?
I believe that the $30,804 that we're requesting for the leach field that was requested includes no Schmuser Gordon Meyer money, period.
And so the number that staff was put on the table really had to do just with the consulting, engineering, and actual physical work of replacing leach field number 6. That's the leach field that was replaced. And then the potential contribution to leach fields 1 and 2, and that's consulting, engineering, and excavation. That's where the $93,000 number came from. So there's no legal fees. There's not any reimbursement on the water system or engineering there. It is simply the physical infrastructure of the leach fields and the direct design work associated with those leach fields. So just to be clear on what's...
I appreciate that. So the staff recommendation at the $98,000 is a little less than 40% of the entire amount expended and expected to be expended to repair 3 leach fields, have put in the new water system, and the expenditure of having gone down the road of litigation, which did not pan out. So it's less than 40% of what these units are out right now.
And that was essentially why this has gone on for so long, because it was a discussion about, well, we can't assume all that responsibility. You initiated the suit. Why would we be involved in reimbursing you for something you initiated, and so forth and so on? So to now come, and that was essentially the terms of the discussion. And so now to come and say, well, you need to pare more away. That's forgetting history, and it's being unfair to the people in front of us.
Okay.
I just wanted to make sure
Yeah,
we're on the
no,
same
I
page.
appreciate that. And how many units total are? 15. There are 15 units, and they're a mix of category 4 and a few 3s?
2, 3, and 4.
2, 3, and 4. So I know category 3's top income is $75,000. Category 2's top income is, I'm not even sure right now.
I qualify category 1 and I'm in a category 4 unit.
Yeah.
So, that maybe tells you something about the financial situation that we're all in. In order for me to have housing, that's what I had to do.
Yeah.
So,
Again, I think that this is just a pretty huge burden to put on 15 units if we're expecting it to rebuild to a safe capital reserve amount, an ongoing sustainable, viable, affordable housing capital amount. We're letting them negotiate or pay off, however they have to, all the legal fees and a significant amount of the actual capital cost to repair the problems from the original construction. And we were partners in commissioning, contracting for that original construction. I would really just please, again, urge my board to consider, let's see this finished rather than coming back in one way or the other or being approached by the housing office in executive session is what direction do we want to take if they have units going to foreclosure and threatening to have lifted the deed restrictions or other issues that are going to result.
Can I ask a question?
Yeah, Rob first and then Michael.
Are you being sued by the attorneys now or anything like that? What's the relationship like?
We're okay with that, but we try and pay them a minimum amount every month. So
One concern that just popped into my head is that that we allocate some funds towards this, and then the legal they sue you and they come after this money, and it doesn't solve the leach field problem. And where are you guys at that point?
Well, we can make sure the money is dispersed strictly to the contractors on the leach field and never passes through the homeowners association.
I just wanted to bring that up as
No, it's
a
a good
thought
thought.
process.
yeah, I can see they're trying to reading the paper that.
Yeah, except for the reimbursement of the one leach field that's already been done. George and then Michael.
Is there an opportunity for the housing authority to participate in this at any level? Do they have any sources of funding, either now or future opportunities, that they could be a partner as well?
George, I have not explored that with the housing authority. I think some of those funds are commingled with city funds, and so we need to, I think you need approval of both sides in those cases. And so It's something we can look at. I do understand that the Housing Authority had some discussion about this. Tom McCabe is out for health reasons right now, and I haven't had a chance to have a discussion with him about where they came out.
Michael?
Yeah, I agree with Rachel. I think we should come forward and approve the expenditures of these monies. And you know, there's a possibility, since the homeowner's structure and fee structure has been such a big deal, is to make sure that the homeowners come back to John Whitman and discuss how to go forward with their homeowners' fees if we go forward with this deal, and put them under the obligation to do that. And then, you know, that's with John and the homeowners working it out, then we can be assured that they're going to chart a way forward with their finances. And I think that's a reasonable expectation and be helpful to them. So I really think we need to go forward and make sure that this leach field stays intact.
Let me get another.
Yeah, I was going to say, maybe we should do this. We have a staff recommendation. That recommendation would be enough to repay for the first leach field that's already been replaced, and to pay for the other two to be replaced if it's done in a timely fashion before rates go up. We would expect to see an agreement with the county, you know, maybe negotiate through John Redmond, as to what will the future increases of the homeowners association be in order to build a sustainable HOA going forward.
I think that's something we all want to.
Yeah. And that would be a commitment on our part here, where'd the memo go, of $90,804.84. How many people would like to support that alternative? 2. Okay. What is the next alternative? 30,000, and we see these guys again in 2 months with the foreclosure? I mean, what? Go ahead, somebody else make a motion, because
That's fine, I mean, that's your feeling, I respect that, but you have to respect other people's
yeah,
opinions
I
as
do.
well,
I do.
so.
I respect it. I just, as I said, I'm not going to participate in further discussions about creating new affordable housing or buying down stuff and then having some sort of lease that says, but we get to walk away the minute you've signed your mortgage papers on a brand-new project. It's just absurd.
That's your,
That is my comment.
that's fine.
We should continue on.
Yeah, Rob, what would you like to offer?
What I'd like to offer is this word foreclosure keeps on coming up. There are millions of people across the country that are in foreclosure now, whether it be employee housing or non-employee housing, and they're making tough decisions with their lives on what they're doing. That's a reality of our economy, no question. There's a place where our obligation begins, there's a place where our obligation continues, and there's a place where our obligation ends with employee housing. I have people in my HOA who are well behind in their dues, and we've talked about foreclosing on them. You know how hard it is to foreclose on a neighbor? You know, these are people in our community. That's really, really tough. But the reality is that there are things of, you don't go into a restaurant, eat a meal, and walk out on it. There are realities of life that are part of financial obligations. Now, this is a very specific circumstance of certain things failing, and as you said, our county contracted for this to be built, but as we've already been told by various people, that our contracts began somewhere and ended somewhere with our obligations. It wasn't, we are going to continue to maintain your affordability at this level, blah, blah, blah. I'm speaking to you because you were very emotional about this and your side, so I'm getting very emotional about my direction on various things. I am okay with putting some money towards this. I'm not sure that it has to be allocated towards one thing or another. But I do think there's an obligation of the HOA to create a partnership in the receiving of that money so that this doesn't, one, open the door for a lot of other people, but two, to make sure that we're all on the same page. Without knowing exactly what that is, it's hard for me to know exactly how much money and say, okay, we'll go for it. Just to say, well, they're going to go into John's office and come up with a plan for their dues. Well, there are 3 guys in my HOA that I would like to have come up with a plan for their dues because it's costing me more money in that HOA. And the reality is when it starts costing me more money, then maybe they shouldn't be living there because they're putting that burden on their other tenants. And,
Okay, so you don't have a number. Does somebody else have a number that we might be able to reach some closure on today, or are we just going to revisit this again? I mean, who has a number that we can reach a 3-person majority, and then...
I would support reimbursing for the original leach field, because that's the one that actually had to be replaced. These other 2 are sometime down the road, and we don't know when. Down the road, my leach field's going to have to be replaced. I don't know when. I put money aside. And I would also like to visit with the Housing Authority and see if there's an opportunity for them to help participate at some level as well.
To the best of my knowledge, the Housing Office does not really have independent funds. They have funds from the city. We pay out of our general fund. Half of their operating funds each year we share with the city. They receive some gift from the Benedict family, but it was for new affordable housing. I don't think they have the flexibility to use it on repair work or as an emergency fund, but we can double check with the Housing Office.
And if I could just get clarification, George, that would be contributing to the 30,804?
Yes.
Okay. We've had one homeowner who's had this hand up, and I've waved him off a couple times. So if you'd like to make a statement really briefly, sir, please, and then I see Jack's hands up.
Well, I've been in this process for the last 10 years. And
identify yourself.
I'm David DeMiller. I'm a member and the on-site manager. You guys all have valid points about roofing, siding, and all that. But you know what? It really comes down to what Michael and Rachel are saying. We had expectations moving into this beautiful property that was created down there. But as soon as we moved in, all 4 tires went flat. I mean, things started happening because the quality of water deteriorated everything, which is the cause and effect of why these leach fields have failed. It has nothing to do with us not doing anything. Our members and board have been very proactive. I was told by the engineer that put in the septic system, you don't have to pump those leach fields for every 3 years. I do it every 2, just to make sure it doesn't worsen the problem. So it's kind of an insult to our intelligence saying that, we're not doing anything, we need a little more action from us. God, we've been behind the 8 ball from the get-go. And there's nothing worse than trying to swim out from that. And that's why we're here, again, as you say. So it would be nice if you would take away all the other variables of what our responsibilities are. We were given a product that wasn't completed to the fullest. And we should not have to carry that burden. Thank you.
Michael?
Well, what about, in the hopes of reaching some kind of good solution to this, what about paying for the repaired leach field, $30,000? And then, which is George's proposal, but then committing funds, say, for the next 7 years. If there's a failure within the next 7 years, then we'll replace those leach fields. Not committing the money all up front, but committing it on the basis of if there is a failure. And that would encourage, and also I think to address the questions about homeowners' responsibilities, to build a relationship with John so that he can help guide them. But that, we don't expend all the funds immediately. If they get past the 7 years, there is no obligation to spend money. If they fail for some reason, we can assume they fail because of past practice and past use, and we'll pay for it. That way, we're very close to what George is suggesting.
George, would you respond?
What I'd like to see as part of that proposal, Michael, is that the homeowners come up with a plan to participate in that. So again, we're sharing the responsibility. This is again where I had a problem with the amount that we allocated to the Woody Creek HOA, because it would have cost those homeowners an additional, it was minuscule, it's like $5 a month for them to have just participated and made up the difference of $40,000. And the board decided to not to go that route, and that was fine. But I would like to see in this scenario that the HOA comes up with a plan that if those 2 leach fields need to be replaced within, if it's 7 years or whatever, that the HOA will participate up to 50%. So you have some responsibility for your units. This is taxpayers' money. This is not per se our money in a sense. This would come from the general fund, I'm assuming, which is funded by property taxes and sales taxes. So it's public money, and I feel that I'm accountable and responsible not only to the 15 homeowners in front of us, but for the 16,000 taxpayers of Pickett County. And I think that they would want to see some shared accountability and some shared responsibility. And I think they would support the idea of trying to protect and maintain affordable housing. But it's got to go both ways. You can't just come and expect a handout. And that's what you've done. You did that in February, and you're doing this now. You're coming for a full a full relief. And I can work with you, but you got to work with me.
Michael?
Yeah, I can understand that, George. But I think actually they fulfilled that requirement that you're asking for, which is that they're paying their legal dues, their legal fees. They're paying 60% of this bill that's been presented to them, and so that's a really significant proportion of participation. And I think you're forgetting that. It's just difficult for me personally to lecture people, whether it's at the Woody Creek Homeowners Association or the Pick and Iron, or actually anybody in the county, because I get a sense, for the first time, at least in my experience in the county, that people are hanging on by bloody fingernails. And when you're in that position, I mean, I'd be in that position if I didn't have this job, I think, because I work construction, and most of the construction that I've been in is gone. So it's just hard for me to ask beyond a 60% participation, beyond that for people who are suffering and have suffered. And so I think my proposal works. I think we've covered your concerns. They've participated to the tune of 60% of the total fees. We're paying $30,000, which is money we have, and we would participate up to the 60,000 plus or minus for replacement of 2 leach fields within the next 7 years. So I think that's actually a very good arrangement. I think people can look straight into a taxpayer's eyes and say, we've met our obligations to the taxpayer, we've met our obligations of the general commitment of supporting affordable housing, and we recognize that in these times, people need consideration.
Can I just respond to just one last point? I'm sorry. What I'd like to see, Michael, is an increase in the assessments for the homeowners to help to build up a reserve specifically for the need for the leach fields, besides anything else that you may need. And that, as you said, Ted, that you haven't had an increase in assessments for several years. And I think it's time that you need to come up with that, and that's what I'm asking.
Jack?
You know, we all have different views. We're here to serve the public. Obviously, the hard thing is where to draw the line. I've heard a lot that I don't disagree with, but certainly a lot I disagree with. And I'm with you, Rachel. Let's take the discussion of housing off the table. If you want to give up on it like that, fine. You got to live with your own words. I understand George's proposal, and George, please correct me. At the end of the day, what it amounts to is that we pay for the existing work that's been done, and then there's 2 leach fields left, and in X period of time, we would pay for 1. Did I hear that correctly? You know, the homeowners need to...
In essence, right, if within a time period, correct. So in essence, we would be contributing to 2 out of 3 of the leach fields, and allowing the homeowners to come up with a plan to address that last one.
Yeah, I mean, you know, we all have stories. I have one sister that no longer has a job, was in the mortgage industry. You know how long that's been going on now, 3 years. Had to move in with my 83-year-old mother. Not good. My other sister's going to lose her home. That family, the husband worked in the oil fields in Louisiana. So everyone's, you know, tightening. Everyone has a problem. The only thing, the major thing I agree with you, Rachel, is I'd like to move forward, move on this, move beyond this today. And so what I propose is that we invest in, partner in, whatever term you want to use, in 2 leach fields. I'll agree with that. And the homeowners association needs to take the bull by the horns. If John is amiable to working with them, fine. I just can't put that obligation on our staff, because again, that opens the door to every association. You know, we're always here, one level or another, to work with the public and help out, but to come up with a plan and put that on John, that's a little troublesome for me. You know, when I look at my association, it's almost, and this is separate of your situation because of the unfortunate issue with the water, but because we, when I first got on that board, demanded we had a capital reserve, we're going to be able to replace our second roof now. It's 20 years. But I feel, well, golly, did we do the right thing? Well, yeah, we did. But from the capital reserve study, it shows that so many haven't. I don't know if you guys participated, I'm not interested, but I'm using these as general terms. So I'm willing, and this is a compromise for me, to go with George's suggestion, but not put a timeline. Let's just invest in it, be done with it, and move forward and beyond it. And encourage the homeowners to do what Dave apparently is saying. They want to take, and of course the board, but you all want to take charge. You look for some help from us. I'm willing to compromise twice as much as I thought, but and no obligation. You know, there's almost a piece of paper that is traded when we offer the money as a partnership here. There's I don't know how to legally do this, a signature or something that says this is not because of an obligation, or have it understood. This is not an obligation. This is something we're doing because we feel this is part of our job and our responsibility. So I'd like to move this forward and let's not get involved in the timeline and let's just do it. And let these guys have certainty hope nothing occurs, and you have some time, but the money can only use in the leach fields. That was a good point. And, let's hope they don't fail the other two right away, and there's some timing that you can stretch things out. And the money will be allocated certainly only when the leach field is necessary. But you have it.
So,
That's the best I can do, Rachel.
okay. I'm not sure that the price holds the same if they're only doing one leach field at a time, because I don't know that anyone's going to loan them the money to do the second leach field at the time. They don't have cash on the barrelhead to pay for that. So, I don't know how or when that happens. Maybe we just do one at a time. I guess, obviously, we'll just take what we can get as a board majority. That's all that can go forward from here. But I see the offer as being basically Picken County will contribute $60,000, one plus one leach field, towards a total debt of $245,000 that 15 individual homeowners undertook to try to correct effective problems with the project Picken County sold them. And that's why.
Your opinion.
That's my opinion. That is it. I said, that's how I see it. And that is why I'm concerned about going forward with future affordable housing developments. How do we say, what do we give people? Quit claim deed, say, here for whatever it's worth. This works out to over a $16,000 per unit problem from the day they moved in trying to deal with this. And some of those, lower category units, that was probably 25 or 30% of the cost of the unit to have that sort of obligation hanging overhead, separate from building a reserve for the things you normally build a reserve for. This was to correct flaws in the project from when they first purchased it. But we seem to have $60,000 on the table. I think that's round numbers. I'm not sure if it was exactly off between the existing first leach field and the cost of a second leach field, if they can get that same price and only putting in one at a time. If they have to put in two at a time to get that price, we'd have a different discussion.
And just for clarification, I have it at 62,305.
62,305.
If I understood Jack's, which is reimbursing for the leach field that was done, and then half of what the estimate is of the 63,000 for two.
Rachel, may I clarify, did the Smuger-Gordon report say that you should do a leach field right now?
I think the report was more that its lifespan had been shortened, and they didn't know when. But it wasn't.
May I ask the manager?
Yeah, please. Just identify yourself again for the record.
David DeMelmer. Because of the amount of effluent that was visible in the view tubes, they thought they were going to fail immediately. I just checked them the other day, and there's still a considerable amount of fluid in there. Where this effluent is percolating to, God only knows. But so back then, they were anticipating that they were going to fail immediately just due to the level of effluent that was viewed.
Okay, so Rachel, what I would adjust here is, because it sounds like practically and logically you should go ahead and get the second field done. So I would say, because of the unit costs of two might reduce the cost, the one might be a little bit more. I mean, honestly, I'm not involved. I am agreeing with George to replace one leach field. This was the number. He might not agree with, I don't know. But I'm only saying one added two, plus, of course, the original one. And so I'm being flexible if the unit cost goes up slightly, because I was in construction 20 years before I started my own business. I understand some of that. I'm not a contractor, but I ran jobs and all that good stuff. So.
Okay. Jack has proposed a variation on George's concept. think it may be accurate that it's going to need to be released sooner than later. Do Rob and George agree with that approach, or we see if there's something else?
Well, the homeowners could actually utilize that $60,000 and change and just go ahead in the next year or so and just replace those 2 leach fields. Then you've got 3 new leach fields versus waiting for it to fail. Because what I'm hearing is, I think we're going to have at least a majority board support to go forward in that. So rather than reimbursing you for the first one, just use those dollars and get those other 2 leach fields done and be done with it.
Well, we're also going to use the money to pay off our engineering bill.
I
mean, so you haven't paid off the first one yet. It's not as...
We have about $2,000 left.
You know what, George, you have the best and most simple, you got a problem, we solve it in the future. You know, I apologize for being thick, I didn't think of that, but George, you have a way of adjusting my unit cost thing. Just say we'll pay for the 2 other ones, and then their problem is solved. And honestly, you have to financially do what you're wanting to do anyway, and take charge, raise your dues, etc. It's more than 7,000 special assessment like Bob had on his roof. So I'm agreeing with, that's an excellent idea, George, as an approach.
Okay.
And it's a few more dollars.
So the proposal on the table is that Pitkin County will pay the cost of the 2 new leach fields that need to be replaced. The homeowners association will be responsible for paying off whatever lingering costs there are from the first leach field and whatever other bills have accrued. Is that what I seem to be hearing?
I can support that.
Okay, Rob, Jack, George support that. I can't support it, it doesn't go nearly far enough.
If I could just add, if that's the direction of the board, I'd rather the county make a direct payment to the contractor.
Yeah.
Can I add one thing that...
Michael, and then
Sorry,
Rob, he had his
sure.
hand up first, sorry.
Yeah, absolutely.
Yeah, you know, in terms of supporting or not supporting, it's the best we're going to do, given the group. And so this is the best efforts of George and Rob and Jack, a 2/3 payment of what was proposed. So I can go along with that. But I think the lesson learned, I think something we have to carry forward is that the employee housing comes with a burden. It comes with a burden of just primary subsidy. You know, you have to explain those to people. And it comes with a long-term burden, where you're in a relationship that's hard to define, but you're in a permanent relationship with developments, affordable housing developments. And going along with that permanent relationship is, keeping an open mind and understanding that there's going to be further obligations, and they're going to come from all sorts of angles. So I appreciate the $60,000. I think it will be a help to Pitkin Iron. I would have preferred a $90,000, but it's not possible, so I'll go with 60.
I was just going to say that the one thing that I was hoping would be in this, which is some sort of caveat that there is the development of a comprehensive HOA plan, including but not limited to a 10-year plan for future P&Ls, a dues increase in collection that meets that 10-year plan. And that was my hope from the very beginning, that would be part of anything involved here, to say, just plan, now that you know what subsidy you're getting from the county, just plan for meeting the rest of the obligations through the homeowners association's revenue P&L statements.
And your comment, for the record?
I just wanted to say that, if we can now take the information or the money that you're giving us, and we can move forward to create that plan. We have been, do we make a plan to do it ourselves? Do we make a plan with some help, no help, whatever? We didn't know how to move forward. Now we will know how to move forward.
And the reason why I say that, being in a employee housing unit with these sorts of issues, is not assessing and collecting, or at least attempting to collect those HOA dues now, puts the burden on the next buyer. Everybody who sells today is out free and clear from any of these, what in my opinion should have been an increase of dues years ago. So the people who are living there now have benefited from the lower dues, and they're putting that burden on the people that will purchase if there is a sale that happens today. And that to me is unfair to keeping affordable housing affordable, because affordable means that we can place someone into one of those units at an affordable price too.
I could be wrong or not having it exactly, but I was under the impression from a phone call from Charlie Diasarac that the housing office in selling those now is not giving people their quote full appreciation, that the banks are requiring a very large retainage to be put towards this. So no one's profiting on the low amount of homeowners' dues at this time. That's just not happening. Jack has hand up first, then Michael.
I want to thank John Peacock, our manager, for the explanation of some of the numbers in the memo, and apologize to John for my $13,000 error. I just need to clear the air on that. There was my error absolutely in that understanding.
Michael.
Thank you, Rachel. Yeah, I'm fine with the $60,000. I think to now I've arrived at a compromise. To then put on obligations of exactly how to structure in precise terms their homeowners' fees, I think is onerous. And I think the suggestion that they work with John, just for guidance sake, if they seek guidance, if they want guidance, is enough to do it. But I can't really go beyond that point.
I can't say whether it should be within 8 years or 12 years is the challenge I have of when you should get up to what amount. And, I appreciate the board members agreeing to do something, but, no, I can't support it. I feel like we've thrown someone on a lifeline with no mooring to the boat, and hoping that they somehow find their way to the island, and that it works out. And I think we'll see it again, or we'll see other contingent problems, unfortunately. I don't like to make bad predictions when I know they're going to affect individuals' lives. And I just see that we've essentially contributed, again, less than 25% to the cost that these guys have had to bear, and will continue to bear going forward, of a project that had flaws that the county was a sponsor of. And I have a hard time wondering, again, what trust and faith people will have when they get a CO from the county or sold a project through the county. People have a lot of expense in getting into these units. They pay to move, maybe pay to sell their old place, pay for a new mortgage, all the closing costs. And then, I think we've overlooked as a community, perhaps, that there's a lot of challenge on the lower income units when you're doing 2, 3s, and 4s. You're having people who end up working a couple of jobs at least to try to make those mortgages and stay in those places, make those homeowner bills. And then there's not necessarily the expertise or time when you put in these really small projects. I mean, it may have been conceived well at a certain point, but 15 units, it gets really hard to be enough people, a critical mass, to be self-sustaining. Everyone's the treasurer, and everyone's this, and everyone's that, and not be on a municipal water supply system, and not be on a municipal wastewater system. Those are additional, much larger obligations than someone who, can get plowed by the city of Aspen essentially right up to the edge of their driveway, like I do, like I have at Hunter Creek. I have municipal water. I have municipal this. I don't worry about the water supply failing, or whether a small package system will continue to work forever, and whether 15 people can afford to replace it. And that's been our challenge, is that we're getting units for a certain price, selling them for a certain price, but the actual physical construction was generally more, and it was subsidized by the land developer's profit on his side. And so then we're asking people by their dues to keep up the value of a project that was far more than their original purchase price. And I'm just not sure our numbers work out well. So anyhow, that's where the board seems to lie. The contact would be through John Peacock for the details of how to see that disbursement going forward and find out, that when you're going to contract for those leach field replacements and how does that get staged, because we might see different prices by next spring. I don't know if you'll do it this fall or what. So that's all on that. We're scheduled for a break now. We're a little behind the schedule, but I would recommend we still go ahead and take a 10-minute break and then we reconvene our schedule.
Thank you. Thank you.
Thank you. 3:25, and we're a little behind schedule, lengthy discussion on that last one. We will now go to our memos of interest, and our manager will lead us off on that.
Yeah, so our first one, we have Dan Frequan, our communication site manager, here to answer questions. Dan, maybe you can give us a 30-second overview of the fees for use of Pickens County translator sites and what's in the memo.
The board asked me a while ago to see if we could actually charge for any of our translators that we do have on the radio system. And in doing some research, the FCC has made it very clear that you cannot charge for any use of your translator if there's a couple of stipulations. When the radios apply to the FCC, they apply for a certain area to broadcast in. And if we would take that area that they are broadcasting in and say wanted to extend it, before the FCC passed the rules, all of the larger radio stations were putting translator sites all over the United States. And so they were basically taking care of the little guy, little guy was no more able to use the translators. So the FCC went in and passed a law that when you apply for a radio signal, you apply for a certain area. And if you want to translate your radio signal outside of that area, it has to be done by either a third party. You, as a large radio station, cannot go and buy up all these translator sites. So consequently, the way our situation is that if we have more than one translator that is broadcasting the same radio station that's not in their designated area, we cannot charge them for use of that translator. And if we happen to have, also like it says in the memo, is that if we happen to have more than one broadcast company that owns more than one radio system, and we broadcast those in our system, we cannot accept the money for that also. So,
Thanks for investigating that. It doesn't seem logical that we and the taxpayers have to put all the resources into building and improving the sites, and then the commercial operators who make revenue off of selling the commercials get to use those for free. But hopefully there'll be a lot of PSAs and things like that, and we'll go from there. Michael?
But we can choose who is on that translator system.
Yeah.
I mean, we have control of the system.
right.
Yeah.
We might not be able to charge it, but they have to persuade us that for some reason they should be on that system.
Right, yeah. And that's why we're coming through with the new policy where that was going to be presented today, but we ran out of time, I guess. And so it'll be further down the road when our new policy comes up, that what are our criteria to be on our translator sites.
Thank you. And I guess there's no other questions on that matter.
Yeah, I would agree with Rachel. Thanks for the research. It's technical, legal, and we don't have to think about this one.
That's right.
As a revenue stream.
Yeah.
It's non-existent.
It's already been thought for us.
Yeah, thanks.
Okay.
We'd be good.
So the next item in the MOIs is the CCI voting.
Yeah, and this is our nomination. We need to appoint a legislative committee member for CCI. Obviously, right now, we have both Rachel and Jack representing the board at CCI, and I believe there's a primary and a secondary.
Yeah, I'm sitting here looking at the form, and I don't know if they changed it from last year or what. Maybe we just submitted it in our own little Pickens County way. But there were 4 committees that Jack was the primary and the voting member on. and then I was the alternate if he was not attending, and then 4 committees where I was the voter in the primary, and then Jack was the alternate if I was not attending. And if that's okay with the board, I'd love to see us kind of continue that. We just Xerox the form twice and put down which were for which.
And so this is just for setting the legislative priorities of CCI.
So this is just for the one
The other
meeting.
committee structures still stand where you guys have been designated. This is just for the meeting where we're setting the legislative agenda and priorities for CCI.
And that's the
looking-
Friday, October 7th.
Exactly. So it's just for this one meeting.
Okay.
Confusion there.
Jack, are you planning on attending on the October 7th? You know, you're the senior member here. You could have the voting
Yeah, well,
if you'd like. Or we could, both talk about it when we're there and try and reach agreement on which.
well, I'm already appointed according to what we passed in November. Not that I think the way we should do it, the way we always do it. So we ought to put on here, actually, both names, and then put in parentheses below per steering committee appointment. And that way we would handle it. Or we make me.
Let's make Jack the primary and me the alternate. We'll discuss them when we're there, if we're both there together. And you just plan on for sure being there. I'm looking at it and thinking it may conflict with the watershed assembly session anyhow.
You don't have that date yet?
It's
hard.
It's actually the 5th and 6th. I'm just not sure if it ends the 6th. But let's put down Jack and go from there. And it's Jack's swan song year at CCI, so we have a primary voting credential on this session.
Well,
And then when we
we've
get to
never
the-
disagreed
when we get to
anyway,
the-
so.
yeah. And when we get to the steering committees, we'll break them up the way we did last
Yeah.
year as well.
Okay.
Okay, so that's that item. Then the next item will be future agendas.
Two items right now to bring to your attention. On Tuesday, August 23rd, of course, we'll be convening a special meeting to have the first reading of our ballot questions. And we'll also have an event liquor license. That's to replace the meeting that was canceled on the 24th. We right now are looking at moving the Board of Health meeting at 1 o'clock because we think we've got too much crammed in to that 2 to 3 o'clock, and there's really nothing pressing on the Board of Health that we couldn't look at an alternative time there. So
Okay.
we're looking at that. The other thing that has not yet been added is September 7th, our housing workshop that we're looking at adding from 10 to 2. So that's in the process of being added. It doesn't make it into your packet.
Okay. And then the other thing per our discussion this morning, we're going to try to get more time with our attorney on these agendas because we barely have 45 minutes on the next time is scheduled for the 13th.
Well, we have August 23rd, we have a 2-hour scheduled.
September 7th.
Which was a Wednesday, Jack, we talked about, since that was an off week for our public hearing, I had asked for roughly 3 or 4 hours to talk about housing. Okay.
Basically, CCI was September 9th.
Yes.
We might just add those dates if we would supply, or
Yeah, there's and
7th and 16th.
Charlotte just put those in our boxes. There's CCI policy on the 9th. There's CCI policy on the 16th. Jack is going to attend the 9th because I'll be at Club 20. I'll attend the 16th. And then everything again October 7th is the next big meeting for those. So those are your main things, John. Did anyone else have times when they think they're going to be gone so we can start making sure we have quorums? Other scheduling items? No. Anything else on future agendas here, guys? George?
Question, John, on September 20th, we're going to do a site visit at Woody Creek, and then after that, we're going to talk about Lanedo Historic Designation. I wonder if that's an opportunity to maybe stay down there, maybe meet at the Woody Creek Community Center. And does that make sense at all? I mean, will there be any public discussion from locals, or?
Yeah, I'm sure if you told me you're coming.
Will be there.
What is the site?
GSS Properties, that's the...
Stranahan.
That's to look at the potential road cuts. Well,
I mean, we always keep on talking about, we'll move out. Maybe we have the ability to still do some broadcasting, and so if there's an opportunity to move the meetings around other parts of the county so citizens can participate, we've talked about that.
Yeah.
And it seems like this would be a sort of a natural opportunity. But
Now, we wouldn't necessarily be able to do a live broadcast, but we could do the recording and rebroadcast on Granicus.
And Skype, yeah, I'm not hip to the terminology, but Pat said we could do that at any location, am I?
Yeah, we have high-speed internet access at.
and I don't...
Well, I don't
And I'm not sure we've got that at Woody Creek.
Yeah, but I wouldn't, why screw it up with technical details? I mean, really, because in this room, Open Space and Trails tried to Skype with Howie when he was in France, and it just never worked, and it interfered with doing business.
Well, the other kind of question that goes along with it to me is, and this would be something to check in with staff, but the Lanedo Historic Designation and incentives, is that something that needs a site visit as well? Because if we're all the way down in Woody Creek at this GSS property, it may be worth, but again, I'd say check in with staff to see if there's reasons. Is that they're looking for a different designation and incentives than we have in our standard HBC code? That's why I wasn't sure what that meant, or if it's a specific land use application. So
I don't think we should drive up in one car. I think we should drive up in 5 separate cars, just because of the hazards on the Lanedo Road. And we don't want to lose all the commissioners in one view.
Maybe we do. Maybe we
do you think we might be ambushed?
Well, no, there could be just a series of unfortunate accidents on your way up there, because it's such a terrible road. I wouldn't go.
Let's just look into it and see if there's a reason.
I enjoy driving that.
Okay, is there any other future agenda items? Did you have your hand up? Anyone else?
Yeah, I just have a question. I thought it was unusual on September 6th. We have a little note up top, and I had never seen this before. Open space starts at 8:30 in Plaza 1.
Oh, yeah, we had that. But they're having their regular meeting here. They will meet here first, then we join them. So they're just having a regular...
But I didn't know that we actually note when their meetings are on our agendas.
Well, we have just so that we know that we're part of rolling into their regular meeting. I have seen that there before.
So, Jack, at 10 o'clock, we're rolling into executive session, and so typically we just note that.
If they're already here, if people want to come early or whatever, I guess.
But you're right, we don't note it otherwise if we don't have those.
If it's not connected with us. Okay, so we're done then with future agendas. John, I think you probably know as a footnote, but we generally do not have Tuesday work sessions on election days.
Yeah.
I know that's not till November, but just so you kind of don't...
Thanksgiving week was going to be another question of mine coming
Okay.
up for the board, because we have a work session scheduled the week of Thanksgiving on that Tuesday. And
I think we've had no problem with the Tuesday work session. It's just...
before we start filling that up.
The one thing, though, is the tradition of moving the last regular meeting of Christmas earlier in the month, and that may be the same depending on how Wednesdays fall with November.
Okay.
But generally, both of those two shift forward a little bit for the holidays.
November and December.
Yeah.
the shift instead of first, third.
It's more like first and second. First and second. So, but Phyllis would be able to give you the background that's occurred on this.
My mother-in-law-to-be is getting married Thanksgiving week, and I'll be in South Carolina that week. I'd let John know that.
Okay.
Last
That's-
week,
that's-
so
that's a good heads up.
I will be one person who will not be at the Tuesday Thanksgiving week
Work
meeting.
session. Okay.
I will be away also October 19th to 24th, but it does not affect any of our regular meetings.
Okay. I think the main ones we'll get a little closer in and pay attention, make sure we have enough here to pass the final budget by the state deadlines and things like that, and then special meetings. Okay, so future agendas seems to be good for now.
Can I just ask
Michael, you had a question
On
too?
Wednesday, August 24th, it says council due to a bike tour. What is, but people, county employees are coming to work, is that right?
Yeah, we went over a memo, Michael, so we're going to have skeleton crews in a number of places, but our community development office will be closed, but we'll still be doing building inspections west of the roundabout. Planning staff that isn't taking the day off to either volunteer or watch the bike race is going to be setting up meetings again, trying to push west of the roundabout because access into town, I think as you guys saw, is going to be really challenged. We are going to be locking the east side of the annex building. There will still be employees coming in. Some employees will be using their network interfaces and forwarding their phones to their cell phones. And we'll be working from home that day on projects. Clerk's office will be open. Courthouse is going to be open in the morning. The assessor and treasurer staff will be in and open in the morning. We're looking at shutting that building down in the afternoon as it gets closer to the race finish. Again, trying to manage those bathroom facilities and overwhelming, especially our older facilities right now. But yeah, we're not closing down most public-facing departments, but we are having to make significant adjustments to our services.
So the courthouse will be closed to public access during race time, essentially? Is that what you're saying?
Yeah, the courthouse behind you now, the clerk's office has a statutory requirement to remain open, so the clerk's office will be open for the full day.
Yeah, I'm just worried that people might be planning on using the second floor of the courthouse for viewing, and I mean, I just don't know how that, it's a new challenge, so I don't know how it would work. If I were at the courthouse, it's not even the 50-yard line, it's right down on the field, essentially. So people might be anticipating that, and I don't know how we deal with that in terms of.
Do you mean members of the public?
Yeah, like this is a public building, why can't I come in and so forth?
Yeah, and we are, because of the limited, you have the security issues, of course, with the courts themselves, as well as inadequacy of the facilities, bathroom facilities and such, which we think could get overwhelmed pretty quickly in that building. We're trying to limit access. We are still working with the judicial district on what that looks like because they've been calendaring well ahead. And so we're still working on those logistics, to be honest with you.
Right.
But we are planning on limiting access to that building right now.
And that access, are we going to have a sheriff's deputy at the door? Is that how we limit it?
No, we'd probably be locking front doors and then having somebody monitoring if there's a back door that needs to remain open.
Okay. I just think when we decide what we're going to do, we should let people know that it's not.
Absolutely. Okay.
Yeah. I would just be a little more concerned about the landscaping and lawn.
Yeah, I don't know if
Getting
there's
totally trampled, but hopefully people
Or
will
climbing
trample.
up on the statue, or, I don't know.
Yeah.
I just don't know what to anticipate.
Yeah. Okay, so we're going to find out. One way or the other. All right, now we're into open discussion, and I don't know if you had Dan stay for another item.
I wanted Dan to stay, mostly because one of the items you'll be considering tomorrow is a resolution submitting ballot language around the translator system. And we had staff's recommended language, which we were having reviewed by bond counsel to make sure there weren't Tabor concerns. And we actually got that language back pretty late on Friday. And so you'll notice that the ballot language in the resolution is different than the ballot language in the memo. And that's because we plugged the ballot language from the attorney into the resolution. And I'll take ownership. I did not also see that changed in the resolution. And so I just wanted to point out to you that as you're going through your packet before tomorrow, which I'm sure you all do, is to realize that the correct ballot language and the ballot language as reviewed by the bond attorney is in the resolution, not in the memo. And they're significantly different. So,
for me, who gets it all online, what are you talking about?
So when you're going online and you look at consent actions first reading, it'll be number 8, and you click on resolution, Michael. There's going to be a staff memo first, and in that staff memo, on the first page there, I believe it's the first, I'm sorry, it's the second page, about halfway down, you'll see staff recommended ballot language that starts with shall the purpose of the existing FM radio and TV. That is the language that was changed because we are making a change to a voter-approved revenue. It does have some Tabor implications for both notice and language. And so if you go scroll down into the resolution, on the first page, you'll see the recommended ballot language. And I can just read it to you right now. It's without,
Go ahead, please.
without raising taxes, shall the purpose of the Pickens County FM radio and translator property tax be used for the sole purpose of funding all costs related to the continuance of the Pickens County FM and radio translator system, and to research and extend wireless communication and internet services to rural areas of the county. That's the language that the bond council came back with, and so that's the language that we'd be asking you to approve. I just wanted to bring it to your attention because that's confusing.
Yeah, I mean, I just want to make sure that I have access to it, because I don't access it on paper. So.
Yeah. We'll have a longer
We'll have time.
discussion about that tomorrow, but I do want to just kind of put a small footnote out there, really for people to have the chance to think about tonight. And it's not to argue the merits of asking a question or not asking a question or moving forward this way, but I asked John when I saw him yesterday, have we put this out to any of the caucus areas yet? And I don't think we really have. And, it's very little notice for citizens who might be interested in the successful passage of this to really get involved and find a way to work to educate the public about what the question really means. And since we're borderline of putting it on the ballot tomorrow, there's no new staff work that can be done. So when we were first talking about this, I had said, well, can we at least prepare some maps of where there is or isn't coverage, so that if somebody asked, well, how big a problem is this, we would have some idea to answer the question. We're not going to have any supporting materials whatsoever, other than, boy, would it be a good idea for economic development. And so I want everyone to really think it through for tomorrow to decide, are we premature on it? Because if it goes down, that's kind of the end of that discussion for a long time. And I think you have a lot of citizens in Aspen who may, again, fall back to well, I have Comcast, I have my services, why should I vote for this question? And without some citizens organizing themselves and planning on educating the public and taking that on, we might be rushing it to an unnecessary and premature failure at the ballot. And so that's my caution, but I think we can discuss it fully tomorrow. But I just realized, again, when I talked to John, no, we won't have any maps of where there's poor coverage. We won't have any maps of where we think this is needed and could be expanded. We will to the extent any of us are questioned or asked about it, or there's a debate about it, have to speak in some pretty broad generalities. And we, again, have not really even noticed the caucus areas where they're looking for this improvement in service, that, boy, there might be a valid question you guys really need to get behind. Michael?
Yeah, but I think the opening phrase of without raising taxes immediately assures that it's going to be passed. I mean, if you said we are going to raise taxes, then we.
Yeah.
But this is just a language adjustment essentially. So I don't think you could actually prepare for this, given the vagaries of technology.
Yeah, and it is, I don't know if we, again, to have it tomorrow will be what we need, but any indication of how much of the existing budget would we be reappropriating towards this purpose should the question pass? I think we should at least be able to answer that, at some level, and I don't know what.
But we're not asking that. That's the whole point.
We are asking the ability to use the existing revenues that way.
Well, but it's just a proposal change in language. So I think once the discussion comes up, whether we spend $1 million on getting internet access to remote parts of the county, that'll be a public discussion. It'll be merit a lot of involvement. But this, I'm not so worried about.
Okay. Jack?
Yeah, I'd like to clarify my understanding of state law and election law. Once we initiate this on the ballot, we cannot, meaning the county government, in any way, shape, or form promote it thereafter. But we can provide some information, education materials. And that goes to your point about maps. I still think we could still ask for that to be provided, so we are knowledgeable, caucuses are knowledgeable. We still have the ability to provide information, pure and simple information, not promotion.
Yeah, I agree with that. I've just always known the attorneys to be very cautious about what one person thinks is pure information and other things is somehow biasing for or against the question. And John, I'll let you answer on that.
And where the line where we need probably to talk to John Ely is this isn't information that we have readily available already that we could just collect and deliver. It would be information that we would have to produce.
Direct.
And that's where you start to get into more gray area.
Yeah. So, anyhow, it's just
And
really
I would
for...
request that to be requested of John, just so we have maybe a little background.
Sure.
Because you
You
raised...
mean from John Ely?
Yes.
Okay, tomorrow, so he can weigh in on that. Again, I'm most interested in the successful question. That's the other reason I raise it. I want to make sure we're not ahead of ourselves. Okay, are there any other open discussion items, John, you need to bring to us?
No, I just wanted to make that clarification.
The only open discussion item I have is, I gave John Ely the sheet about it. I didn't realize I would be seeing him again. But there is a BLM hearing on Thursday of this week in Glenwood Springs about the Rudai Reservoir and the whole Fry Arc project revenues. And the Fed's, the Bureau of Reclamation is looking towards some sort of new process of how to allocate excess revenues. And they're having a hearing here, and they're having a hearing in Pueblo. And the Front Range communities are competing pretty heavily for the idea that any excess revenues from the Fry Arc Water project should go to completing more of the delivery systems on the eastern slope. And the River District and Rudai and some of the others are very interested in saying, no, some of those excess revenues should go to pay off the Rudai debt, which, Michael, you may know is in the tens of millions, and is supposed to be fully paid off by the year 2017, 2019. And that was what Dave Merritt referenced when we were down in Garfield County last week. So I know I'm out of town. I'm leaving for a wedding on Thursday. I don't think it is a listening tour. It's not the final comments have to be due by then. I had sent Mark Fuller an email over the weekend to ask him about it, and he said he's out of town, and that he would be preparing some RUDI comments for the formal comment record, but again, wouldn't necessarily have anyone there for that listening tour. So if anyone, we can get the more date and time back from John Ely tomorrow, but if anyone really wants to go or has the ability to go and put a few bullet points in the public record, that is certainly a good opportunity. We'll have to talk to John, see how quickly.
Can you share that with us? What day do you think it was?
I know it's this Thursday, because that's why, Thursday the 11th, I think it's the Hotel Colorado. But again, I gave John Ely the one copy of the memo I had to make sure he knew about it. I apologize, I just have a real bad headache today. I'm not forgetting something, but
Yes,
keeping all my notes together.
I would think we would support certainly putting revenues, excess, I don't even know what excess revenues mean in terms of how much, but paying down that debt.
Yeah, I really think that
Pretty
they
important.
need to pay for some of those other ones. The other one, John, we talked about yesterday, there's a comment period due by the 12th of this BLM.
Right, and Ellen is working to bring to open discussion tomorrow some recommendations
Okay.
for that response. I know we've got a huge agenda tomorrow at a very short turnaround time, and she's checking with Thompson Divide Coalition and such. Will Roush had sent some recommendations to us. Some of them involved Thompson Creek, or Thompson Divide Creek, Thompson Creek, and it wasn't clear how that matched up with Thompson Divide.
Is this about Secretary Salazar's latest?
Yeah.
So I apologize, it's going to add to tomorrow's long agenda, but we'll be coming to open discussion to chat with you guys about that tomorrow.
And we do have one item, just talking agenda, that's been deleted from tomorrow's agenda, and that's the campaign finance.
That's correct. Yeah, and we'll pull that off. It's already been noticed, so we'll do that during additions and deletions in the morning.
Okay. Any other open discussion items? I do not have anything under my notes. We'll go to the next item, which is Mary Lackner, GIS. Discussion of redistricting.
Do we need a couple minutes?
If we could.
Yeah, why don't we take just a couple-minute break here, guys, stretch our legs, catch a little of that
There's more
sunlight.
cake if anyone needs some.
Cake for everyone, cake all around.
Can I get you something for your headache?
No, I have some more aspirin in my purse. I think I'll take it during the break. Yeah, I hope you're not coming down with Grassroots TV, ready? Thank you for being here. We are going to hear our presentation on redistricting. So just introduce yourselves for the cameras.
Mary Wagner, GIS.
I'm Dwight Shellman, the election manager. If I could just briefly, just kind of recap for the viewing public. We came before you also on June 21st to talk to you a little bit about redistricting the commissioner districts. And Mary at that time presented a couple of options to equalize the populations in those districts, which is the statutory requirement. The board, at the conclusion of June 21 work session, asked Mary to tweak the options that she had presented, and she has done so and will present the tweaked options to you today. Just to refresh your recollection regarding the legal requirements here, the law requires that the Board of County Commissioner districts be as nearly equal in population as possible. The board has historically applied a plus or minus 5% deviation as being permissible, and the statutory deadline for completing the process is September 30th. So I think what we'd like to do today is present Mary's work, get your input, and then we will proceed to a formal resolution for first and second reading at some meetings in September. And I haven't scheduled those precisely with Susan Murphy yet, but we will get that on your agendas.
George.
I have a question on that. You said that there's a state requirement for county commissioners to adjust districts by population. Then you said that, I think you said that Pickens County decided to come up with a 5% as a gauge. Was that correct?
Not completely. The 5% deviation is in the law, but technically it applies to the state legislative reapportionment process, the state house districts and the state senate districts. As a practical matter, this board has kind of adopted that deviation in the last 20 years that I recall, where when you've redistricted, you've applied that deviation. And I can tell you that other counties do that also, just because it's the only guideline from state law that we have, even though it technically doesn't apply to commissioner districts. And it's just simply impossible to draw the line so that the populations within each district are precisely equal.
So then, this is based on this past census. And the last time that was done was 10 years ago. So 10 years ago, based on the census, was there any redistricting done, you recall, Jack?
Yeah, we moved several boundaries, attempting to stay within drainages, for example, and like communities. Put that in quotes.
Communities of interest in those
Yes.
Thank you.
Okay.
Mary.
And do we need to turn the lights down now, or?
Sure. I have both the website and some ArcGIS stuff that I can show you, but most of your information's in the packet. And what I wanted to show you on the overview map for each BOCC district, there's option A, B, and C is the hybrid that we had come back with. What I've added to the front map are ID numbers for each of the polygons, and then behind each overview map is a detailed map showing the aerial image and basically the population of that area that we were looking at changing the district to. So the overview map has, say, an ID of number 12, and then when you flip to the next page, you have ID number 12, and that has the population of 199. The proposal there was to go from BOCC District 4 to 5. We know that that was one that nobody really liked. But what we're doing is continuing the two options you were presented back in June, and then doing the hybrid and the third option. So those are the details of what the various maps are.
Let me ask on that, because I did have a little bit of a hard time following this at home. So again, just on our first page, option A, up by the old snowmass section, you have ID 12, ID 13, and ID 20. And so those are distinct populations that you are saying could be moved and still maintain this sort of balance.
Yes.
Okay.
So then when you go to the second page of option A, there's option A, it says ID number 12, and it shows that area, and it's a general description of, that was the old snowmass area, and it kind of gateway to Snowmass and Snowmass Creek Road.
Mary, do you have that on this, can we have it on the screen? Can you show us on the
So
screen?
we can put that on the overhead, unless you have this.
I don't have the PDFs on my computer, but
Can we switch to the overhead, John?
I mean, just the reason being that we're all looking at the map, and you're looking at the map, but nobody else is looking at the
actually,
map.
let me see if we can do this. We can probably do it this way.
Find the memo.
The what? 12. Go here. So this is the area that we were discussing. So let's lay this on here.
Well, let's just do it out of the memo, because the public might have access to it.
It's easy to...
Yeah, the overhead.
Oh.
If you can turn it to landscape, it might all fit on there.
Here you go. Yeah, and a little less glare, too.
Am I upside down?
No,
No, that's perfect.
that's perfect. Yeah, that's right there.
That's the way we see it.
Okay, I won't touch it anymore.
Yeah, because the glare is just...
If you use a pen there, you can just kind of point to what you're talking about.
Yeah.
It'll
So this was one of the options discussed, and over here is the highlight of that area that we were talking about in the inset map. And I do realize that was one of the options you did not want to pursue.
So when you say options, could you explain what you mean by option? That we were going to remove this from one district and put it in
Yeah.
another district? Could you tell
Yeah,
me that?
and what's happening is, with the latest census, the populations of each of the districts have changed. So District 1 actually needs to gain almost 1,000 people. District 2 needs to gain about 400. District 3 needs to gain about 1,000. District 4 needs to lose about 550. That's Snowmass Village. And then District 5 can gain about 216. What Dwight was saying about the plus or minus 5%, because you can't have exact populations in each district, because the way the census data comes to us, they come in blocks, and you have to grab contiguous areas, and you basically get that population of the block. So there's going to be some variation in that, and the plus minus 5% is actually 342 people.
Either way.
Either way. No, total span.
Oh, I'm sorry.
That's the total span. So the other thing that the overview map shows is for each option, if you took all of the, I think there's 7 or 8 about changes within each option, and down here, it does show, this would, but the resulting population would be, to get it to the ideal population.
So, just to be clear, can you switch to the other detail that you were just on? What the option A proposal was, moving the highlighted yellowish area there from Commissioner District 4 to Commissioner District 5, correct?
Correct.
And that was, as Mary indicated, an option that the board what indicated it wasn't interested in pursuing. But what Mary's done is redo the maps, hopefully to provide more detail. So we'll review all of the options, and then we'll get to option C, which is the hybrid option that the board directed Mary to try to come up with.
We're very fond of hybrid options.
We are. We are a hybrid community.
And clarification, was option B on the table? That was included last time?
Yes.
Yes.
And the direction was...
And the C is the newest evolution.
Yeah.
Hybrid, quote unquote. Thank you.
So I don't know how much of detail in each of these polygons, but what we're doing is showing, okay, this is what each of the changes entail. This one, again, in the upper right-hand corner, it says if what options are proposed under. So you'll see under 2 and 3, or excuse me, options A, B, and C, like some of them carry over in each option because they seem to work pretty well. This one, Snowmass Canyon Properties, if you look at the overview, if I can switch this way, right. If you look at just the BOCC district boundaries, you can see that there is this interesting jog where District 3 comes into Snowmass Canyon, and it's paralleled by highway, or it goes along Highway 82 and Lower River Road. So the properties on one side of Lower River Road are in District 5, and the ones on the river side of Lower River Road are in District 3. So one thing we're looking at doing here through most of the proposals is actually taking the properties between the highway and Lower River Road and putting them in 5, because it just would make sense.
And that is contiguous already. Well, yeah, it shows it.
Yeah, this
Contiguous to 5 already, it's just
it is contiguous.
clarifying.
In fact, people across the street with the opposite, the odd or the even number are already in that district. So this second option, so I click there, this is cool, is actually, this was an original proposal saying this part of it goes from 5 to 3. In the options B and C, you will see this going the other way. So this is, again, an option we threw out there the first time, didn't really hear a lot on that, so we're moving forward. This ID number 20 is something, it seemed to be well receptive last time. This is moving the Aspen Village and Jabasdale area out of BOCC 4 into 3. It's 372 population. It works well with the district boundaries, and we really do need to drop the population of 4. It is not affecting the caucus area of
Woody Creek?
Snowmass Capital.
Snowmass Capital.
Snowmass Capital.
Yeah, which the other option was showing. So you'll see up here in the legend, it does say this is being proposed in all 4 or all 3 options. Are there comments on that question?
Well, Mary, the other option you had along Snowmass Creek, that's actually sort of in the Woody Creek caucus area. And this is not in the Woody Creek caucus area, so you're taking one out of the Woody Creek caucus area and adding another that isn't, I mean, it's, I can live with it, but it's, in terms of communities of interest, you've just switched it all around.
I didn't follow that.
Well, the Lower River Road is in caucus area.
Is it a Woody Creek caucus?
In the Snowmass Canyon area. That picture was pretty...
That's Lower River Road.
Right.
That's
So
in the caucus area.
caucus areas on this map, this would be caucus.
Let's let Mary finish what she's doing here, and then George's question.
So that is Woody Creek Caucus. So actually pulling it the other way. Right now it is split, so the green green boundary between these roads, so that is showing it is Woody Creek Caucus, and that, yes, we would be adjusting that.
So
You'd be
becoming,
adjusting it out of Woody Creek.
We would be adjusting it out of the Woody Creek Caucus.
And
But
the
right
other
now,
part that you're adding in, the Aspen Village, is not in the Woody Creek caucus area, but you'd be adding that in. So in terms of community of interest, you flip-flopped everything. But I can keep going, we don't need to have a...
yeah, that's okay. And
Well, I
George,
just want to clarify, because on the, let's see, district,
Which ID, George?
on option A, ID 13, that same area, you actually taking that area from District 5 to District 3, which would be inclusive of the Woody Creek Caucus boundary areas.
yes.
Okay. And then,
I understood differently, I understood that it was being taken out of district.
no, look at option A, ID 13.
I've got it.
And it says BOCC District 5 to BOCC District 3.
Yes, so that is the reverse.
So that is actually
Yes.
bringing it more into...
Okay, then, so we're
Compatibility.
but that's not what you just said.
Right, because other options go the other way.
so option A currently keeps the caucus area in 3 and actually unifies it.
Yes. Yeah, okay.
Okay.
All right, great.
Because currently that area is split between 3 and 5.
I never knew that.
The Highway 82 side is in District 4,
Correct.
which is the other side of the river.
Option A and C are showing, the Maroon Creek Club, Moore Family PD, Highlands School area, Meadowwood, and the Tennis Club subdivision area is moving from BOCC District 3, which was
Needs to lose possibly.
lose, into BOCC District 1, which needs to gain. And that is actually a fairly large area, handling 948 in population.
And that district is what, 1,000 or something short?
That was the most short.
Yeah, needs to gain about 1,000. But as you can see, if we take Aspen Village out of 4, put it in 3, then Moore has to adjust out of 3 somewhere else. So it's kind of a cascading problem.
And that includes all of Highlands.
It does include all of Highlands, Moore, Eagle Glen, or Glen Eagles. There's Proctor in there. So that's proposed in both options A and C.
I
This-
like this one.
This one I'm not going to focus on too much because there's no population, and there will be other adjustments when this actually comes back to the board for reading, because instead of following the boundaries as we have before, such as city boundaries, which is what this was, it's a de-annexation area from the city, and other things, Dwight has mentioned that we want to go by census blocks, and we'll look at that at the end of this presentation. So it's no population.
It's just basically moving a fairly large unpopulated area from one district to the other, just because
And it makes
the
it-
boundaries make more sense, it
Makes the
seems to us.
contiguity work. Okay?
So this is an option that, it looks like it would make sense for all of them.
Basically, as it is now, Burlingame Ranch is split between two districts. You can see this is the developed area of Burlingame. It is in 2 and 3 presently. It was developed since the last census. The census block itself cuts across this whole area. So we are grabbing the adjacent census blocks and putting it into BOCC District 2. At the last census, it had 128 in terms of population.
What is that chimney on that top-looking house thing that scoots out there to grab like one more person?
That's where Connie Harvey lives.
It just seems like an odd...
It is the configuration of the block as well as a parcel. It is an open space parcel out there, and it is, it's the house with the chimney is what it looks like. It is the configuration of the underlying data.
So that's a continuous parcel that just looks like that.
It's not really a parcel, it's the configuration of the census block. And the whole point of grabbing entire census blocks and moving them is because census blocks are supposed to remain consistent from one census to another. I don't know how true that is in practice, but...
That way you can measure population gain and decrease in the same baseline material.
So, and if you look in the state statutes, how they actually legally describe a state legislative district, they say, for example, House District 61 consists of census block 4571, 4572. I mean, they literally describe it by the census block. So, in any event.
Yeah, and it's the city line, it's a parcel line as well as actually a census block line, just that configuration.
Mary, question, that the other part of the chimney, is that the old Burlingame Ranch? Was that what we're seeing there?
I think it's called...
Because it says Stage Road PUD, well, I'm thinking...
Well, part of that would have been the Bar X Ranch.
Well, that's the old ranch, right?
Yeah, that's the Bar X, and then the other side of Burlingame was the Pepke Ranch. So they've merged into one project there.
Right, okay.
Deer Hill and what was the other one?
Deer Hill and Red Butte kind of are on the bookends to that.
Yeah.
Visually from this, GIS view.
So in the Burlingame, the next phases are coming in this area here. So it will be more developed on BOCC 2.
The bowl area.
Loops up into here.
Base of the bowl.
Yeah. Option A picked up some areas encompassed by Aspen Mountain Road, Midnight Mine Road, and Castle Creek Road, a population of about 20. We didn't really get a lot of feedback on this last time, so it was only shown in this option. We don't need that to be contiguous to put the other stuff to the option we just showed. We don't need this to have the other things happen.
Yeah, but you need it. Otherwise, something else is going to have to reach way around those other things to grab those 20 people.
Right. They can. It was just an option to show.
But if they're not in 1 and they're not in 2, something else will have to grab around some ones to get those 20 people.
Yeah,
which would be District 3, I
We're
guess.
proposing to leave them in 1 and actually not do this adjustment in the further
Right.
alternatives.
Okay.
So option 2, or option B, same thing, overview map has various ID numbers with the detailed maps.
The only thing I'll say about all 3 is that District 2 is just so contained in the urbanized area. It doesn't. All the other districts reach into a little bit of urbanized per se, I guess 1, 2, and 3, but then 2 is the only one that's just really strictly urban and doesn't, extend up or out to any open space areas. Well, Forest Service areas or anything. I don't think it particularly matters, but that is the very smallest and the most compact and the most urbanized district. You almost can't see it on your maps. It's so small, it's so tight, you know.
Yeah, it's the dense population area. So here's the same, we're looking at the ID2 for the Aspen Village and Bosdale, that move again. This one, we're not really discussing that. This is the same option we're just looking at with the Burlingame Ranch and Stage Road, going from 3 into 2, where there is already a population of Burlingame Ranch. For option B, this is showing Mountain Valley, Eastwood, Knollwood, Aspen Grove, Snyder Park, Ardmore, going from BOCC District 3 into District 1, and that's about a 503 population. So now we're looking at the adjustment more on the east side of Aspen as opposed to the other one we were looking at around the schools and the highways area. This one has a nice boundary of Highway 82, but then it gets a little funky as you get into town and pulling the various properties and census blocks and keeping them contiguous up in this area to get a consistent population. We also have some commissioner residences in that area that we ought to make sure it stayed in the current districts. So there's some challenges there.
That's always good.
Is it possible
Thank
for
you
you
for your
to...
service, Rachel.
Thanks for letting me stay with
Is it possible for you to pull a close-up of that
Yes.
urban area boundary change?
Yeah, and I have two types of close-ups, and one is a web map that is available to anyone who has internet access, and it's at this address. We don't have a link to it on our website yet, but we will put it out there. It's this server address, 205.170.230/BOCC 2011. And that does show all these options, the census blocks, the current configuration. What's nice about this is people can actually go in and start seeing what is contiguous and what is not. And that's an idle film of it. So we'll look at it.
And that website allows you to do all these little
This is the
restrictions?
website.
Oh, wow.
Yeah. So over here, if I pull open the options, I've got the outer boundaries of the different A, B, and C proposals, and then I also have proposed change by ID number, which corresponds with those PDF maps. The server product, this application doesn't support transparency, so that's why you have to turn on and off the polygons. So this is that area that we were, actually, it's the red area, number 98 we were looking at. So if I, we were looking at option B. Option B. Yeah.
So it's adding that right-hand portion from District 3 to District 1.
Yeah.
I think it makes sense in terms of just keeping geographically these things a little more together.
And then, since we're in this product, I want to show you that you can turn it off, census areas, voter precincts, the urban growth boundary, as well as other information such as property boundaries. This is the real constraint, though. The census block population, if I turn that on, you'll see that we're configuring the boundaries based on the population of these different blocks. So if I select this block, you'll see it is census block population. It has 119 people in it, but you can also see I don't have a lot of choice in, see how it flashes, in cutting it up, saying, I only want the upper part of this to add in because that's in the county or something. This is the whole configuration of that block, so we're somewhat constrained. And you'll see that is how we're going to describe these in a legal description, is by census block number.
I should call them census amoebas.
So
Census blocks.
So right now, that census block is split between District 1 and District 3.
Yes.
So in doing this, we're bringing the census block back together. Right.
Yes.
For whatever that's worth.
Yeah.
Exactly.
And that makes sense because if you look at where that green line dashes across that particular block, the census tells us there are 119 people in the whole block. It doesn't say how many are in that little portion that's in District 1 versus the rest in District 3. So you really can't split up a census block. It's kind of an all or nothing deal.
A question, is this a census block, that little gray?
No.
And down here, what do those little...
Actually, let me see. Some of them are quite small. This one might not have any population in it. Let's see if it has population of 3. And then this one is another one here, and that's going to have a slightly different population. I go to population that has 19 in it.
Jack, over underneath this listing of contents, the map content down under census block, it has it color coded as to how many people are in each one of those blocks.
Yeah. And the ones that you can see through, like this one here, does not have a population. So there is this detail. It is out there, available to you, to the public, to look at this and the various options that we've proposed.
And there will be public hearings on these when they come forward after we finish the work session. And I think, Dwight, you made a really great comment at the last work session on this, that the public should make themselves aware, especially anyone who's interested in potentially running for one of the seats that would be up in 2012, just because it's more timely. But if you're interested in running for a seat in 2014, you may want to pay attention as well, because you may or may not be in the same district you thought you were before.
Exactly.
And I don't know of anyone, maybe others do. This is not about any individual races or people, but this is how it most affects the public.
That's absolutely right.
Okay.
This is showing that Lower River Road actually going from 3 to 5, but I'm hearing the other proposal taking it from 5 to 3 is more consistent with the caucus founders.
Wait, it's currently in 3?
This little sliver between Lower River
Right.
Road and Highway 82 is in 3.
And it's currently in the Woody Creek caucus area.
Yes. Whereas
Okay, I see what you're saying, is not removed.
This is a different one than we saw.
This is a different sliver.
Yeah.
The other sliver is the other side of the road.
Oh, I beg your pardon, you're right, I'm sorry,
Yeah.
I was confused.
Option B and C, this is looking at Main Street and Aspen. Basically, the current district boundary was not going down Main Street, it was going down Hopkins, and we've moved it to go down Main Street, and that the properties between Main Street and Hopkins would go from District 2 to District 1. This is looking at taking the ABC, North 40, and putting it from District 3 to District 2, a population of about 550. Questions, comments? Option C is pretty much a hybrid of the other options. The Aspen Village to Boston moving from District 4 to District 3. Looking at the Moore Family, Highlands, Maroon Creek Club, Meadowwood Tennis Club area. This does unfortunately split up the Castle Maroon caucus boundary.
But that has not been an active caucus now for quite a while, unfortunately.
By how much, Mary, off the top of your head? I mean, is it, and Rachel's obviously right, it's not been very active, but is it a dramatic
All of the caucus boundaries already
Because
have...
there's a lot of population right there.
There is a lot of population.
So some of that's annexed in the city and some of that's not.
Correct.
That caucus hasn't been active in about 6 years, at least.
So this is the configuration of that caucus boundary. The orange line is actually the UGB boundary. That was something else you guys were interested in. So the caucus boundary does come all the way down to Highway 82. That's the rural property. It encompasses schools. So it is taking kind of this chunk out of it.
It's taking it out of the caucus?
It's taking it out of District 3 and to District 1.
Yeah, I understand that, but it looks like the Castle Maroon caucus would still maintain that boundary, that, 948 people, and it's losing, is it not losing the more open space, et cetera?
Well, the caucus boundaries don't change.
I know.
We're just moving those people from one commissioner district to another.
District to district.
Yeah. Okay.
Yeah.
So they remain a part of that caucus.
Yeah, okay,
We're not changing
I was
that.
actually reversed.
I think the question is that it's further splitting the caucus between two districts, or more dividing the caucus between two districts. Therefore, they might feel that they have two people kind of representing them versus one person really representing them. That's the way whether that's true or not is a different story.
Well, this seems to make some good sense.
Yeah.
Yeah, part of my impression has been that a lot of the Maroon Creek caucus area was in unincorporated Picken County, and then it slowly, has annexed into the city up to the base of Highlands, and other than Meadowwood, which stays out as a kind of a donut hole there. And so they've moved more to issues related through the city council than communication with the county. And it's been really problematic for our community development office to try to get input from those further up Castle and Maroon Creek roads who are just not really active members anymore. I think when Lynn Mace left and a few others, it just stopped being an active communication link. And it'd be nice if they would kind of reinvigorate with their main concerns from the urbanized to the more rural areas, but I don't know. You can lead a horse to water.
Yeah.
We certainly have tried.
So one of the things, that website, we do have out there, the town boundaries, the caucus boundaries, the UGB boundaries. So you have all these kind of conflicting things. And the census blocks themselves with the population that we're trying to add in contiguous. And so that's why we're getting these various options. Skip that one. It's been discussed. There's Burlingame again in option C. This is that Lower River Road, Snowmass Canyon. And we discussed it going the other way. This is the south side of Main Street in Aspen, going from District 2 to District 1. And since there were some other tweaks we had to do to get the populations correct, we were looking at moving Williams Woods subdivision from District 3 into District 2. You can see the current district line on here, and it would just capture that way. And that's a population of 36. We were looking at also to even out population, the south side of the business center, which part of this was recently annexed into the city of Aspen. It's not taking like the real meat of the business center, but it's that southern portion, and since Pasco Lane and Annie Mitchell is already in this district, we made the line follow the road up there and then Highway 82. And that's a population of 32. There's also from BOCC District 1 to 3, mainly the Park Avenue and Midland Avenue areas and the subdivisions within there. It goes from BOCC District 1 to 3. We have the Roaring Fork River here, Sunny Park, and then we go up King Street, Park Circle, and then grabbing the development in that area. And that's a population of 227. So that's a new option. It gets quite a bit of population, moving it from, like I said, District 1 to 3.
And leaving Rob's house in District 1.
I'm down on the bottom there.
Yeah, I know, but it's getting close. I just want to...
And up here, we weren't able to do anything up in this area, tennis court subdivision and all that, because this is just one weird census block, which is very large. Takes in half of the smuggler trailer park. It was a difficult area to configure.
But that kind of stays the same as it is currently, the smuggler trailer park?
Oh, yeah.
Yeah.
Questions on this one?
Yeah, George, you have a question, look at your face.
When you're done, I want to go back to the very beginning, but finish what you're doing.
Okay, we're almost through. Actually, that was it. And then the back page is the text summary.
So, Mary, can you, when you first started, you said that you gave numbers where you had which districts had to increase their population. Can you go over those numbers again?
Yeah, and that was from Dwight's original memo.
But George, can you go ahead and turn the light on since we...
Is that a memo? Maybe I missed it.
It was the June 21st.
Oh, I haven't got that.
So,
I'll get this for you.
District 1 needs to gain 973.
973, yeah.
District 2 needs to gain 413. District 3 needs to reduce 1,055. District 4 needs to reduce 550. District 5 needs to gain 216.
Okay, thanks.
And those numbers are based on getting to that ideal
Perfect.
3,429, which,
okay.
looking at the census block configurations and how much population and variation there is, that's why we have a 5% variation. And in fact, in all of our proposals, we're actually over slightly on BOCC District 4 because there just isn't another logical census block to take out of there to reduce it.
So basically, just looking at this, because this is obviously it's a little confusing to say the least. But basically, District 3 and 4 need to be reduced the most, and District 1 and 2 need to gain out of those. So the major shift seems to have to go from 3 and 4 to 1 and 2 for the most part.
Well, District 3 needs to gain.
You said District 3 needs to be reduced.
Oh, I'm sorry.
It's over 1,055.
And then, so if you go back to your concept in terms of the consensus block, but also how geographically it lines up and makes sense, wonder if you could focus on, because it seems like when I was looking at it, there's actually some little bits and pieces from each of these you could mold to make that work, but it's like a cubic square to try to put it all together.
I know just what you're saying, George, because I was sitting here looking at this last chunk that we saw, the Regent Street, the very last page of our memo, going, well, it's 227, and that my district's trying to gain 413, and it's so close. Isn't there a way to make that Mitch over? But it really doesn't, because it's surrounded by one, and then you know, as you said, the cascading effect of everything moving around. And then the other things further out would have to take what you had already added into District 2, and so it just doesn't make sense. But even though it's so close, to me, physically feeling that way, it just doesn't make sense.
And let me just recap. If we apply that 5% deviation that the board traditionally has applied, each commissioner district after this process should contain a population of between 3,258 and 3,600. The option C that Mary has presented here, every district falls within that range except District 4, which is 7 people over. And we can't find a way to adjust that. Logically. So I think, frankly, this is the best that we can do within the parameters that we need to work with, and I would not consider 7 people over a material problem.
So then, the only thing that we talked about earlier on option C, it didn't make sense on the very last bottom where we're adding to District 5 from District 3 along Lower River Road, which is part of District 3, so that's part of the Woody Creek Caucus area. So if we take that off, where does that leave us? So we're actually, District 3 is gaining 74, District 5 is losing those 74.
It would be 74 added back into 3.
That's correct. So how does that jive with your overall numbers then? So District 5 loses 74.
If that portion remained in District 3, District 3's ending population would be 3,444, which is within the range. And then District 5, I believe, would be at 3,238, which is below the minimum range by 20.
And if I may, that could be corrected by including ID number 13, which is only in option A, which is the other way between District 5 and District 3,
So then another.
which we wanted to include, which was a population of 52 back the other way, which keeps Lower River Road connected in the Woody Creek Caucus.
Right.
So add 52 to District 3.
No, but we're adding,
You're adding the northern side of Lower River Road.
but we're adding more to 3. Is that what you're saying?
That's what we need to do. We need to
And
add.
then, but District 5 is losing additional 52 as well as 74, am I?
Yes.
And that puts us an additional, like 130 below or something. What I don't have to say.
This side of the
By 20.
This is in which district?
Well, one says 3 to 5, and the
That'd
other
be
one says 5 to
74.
3. So if you include both of them, they balance each other out within 20 votes, within 20 people.
Bob, you're talking about 13?
Okay, we have two different
Sorry,
conversations.
I'm just trying to understand.
Yeah, why don't we listen here and see what they're trying to say and make sure it's the same as what you're hearing, so.
I'm saying I not include ID number 99 and include ID 13. I think
In
that's...
which district? Not include, make your whole statement the same.
Well, it's the whole, it's the option.
Okay,
Option that is referred to as ID 99, which moves 74 people from District 3 to District 5, to not include that, and to include to option C, the map that is titled ID 13. I think that's an important group to keep together, and even if it skews us off more, then adjustments should be made elsewhere. I think that's what you were saying, George.
Yeah.
Yeah.
So that's a priority to put those in.
Well, it's an idea. Michael, what do you think?
It makes sense, I mean, just from a community interest.
yeah. Okay, so we seem to be kind of settling on option C with that sort of adjustment, and I don't know if there's any other small adjustments that people have to make, but seem to be growing support for that option C makes sense, that the hybrid between A and B? That makes sense? Jack?
Yeah, it seems like C works fine, but I'm trying to get a handle on Rob's suggestion here, District 5 to 3, and if we don't do option 13, that means Aspen River Valley Ranch, that Aspen, that's not in 3, and that is in that drainage. Currently, it's in 5. Now, am I correct? That's ID 13. And then the other one was ID 99. Both of those areas would seem to have that areas of common interest to District 3.
Correct.
But what we're going to get to is if both of these go into option, or
Into C.
into 3, 5 will be undersized. And
We'll be
we need-
undersized by 72.
Yeah.
A pretty good
Yeah,
one.
that's what I was...
Which means we need to make that up somewhere.
And if you look at the configuration of 5, you're either going to be dipping into Snowmass Capital or other parts of Woody Creek
Find something contiguous.
to find something contiguous, yeah. So you would be breaking up another area. And that's why, because this seems like an interesting configuration, that's why we focused on this as being a place that could possibly change.
As far as that latter potential suggestion, I certainly don't feel that that's positive, because the areas talked about in ID, sure, yeah, ID 12, Lower Snowmass Creek Road, Gateway to Snowmass, etc., those go back historically. Now, I don't know much about the county before Bob Child's days, and, Michael Kinsley and Joe and Dwight, but those were always in District 4. The Snowmass Capital Creek, not only caucus, but district. That Bob always ran and had Gateway to Snowmass, etc. And that's a census data, what do you call that again, Dwayne?
Census block?
Block. That is a block? ID 12?
Yeah.
ID 12 is our polygon number
Oh,
of
I
this
see.
area. It's so we know which one it is.
But that is it is either a complete, one or more complete census blocks,
Yeah.
correct?
So,
Yeah, I would say maybe one, but not both of those could happen that Rob has just brought up.
so BOCC District 5 really is Crystal River Valley, up to around the Basalt area, and then wraps around in Thomasville and all that. You can see the boundary either is adjacent here to the rural parts of Snowmass Capitol Creek, or even above Highway 82. So that census block has a population of 69. In here, so that could be an option, taking the rural, the uppermost parts of Highway,
Adding it to 1?
yeah, so this would be, adding it to 5. Instead of looking at that Woody Creek, Snowmass Capital, that.
Keep that one home.
The canyon.
Yeah, we could keep 99 and 13 together and maybe do something there where 5 doesn't get so under.
How many are in this block now?
What's that?
How many are in this?
69 in that.
So that gets it very, very close.
Yeah, that gets it.
And that would be taking it from District 1, putting it in District 5, but it would at least add to District 5, which is the threshold 1.
Yeah. But that actually would make sense.
It's not lowering the number of 1 too much, though.
No, 1 we can adjust because it's got more
Yeah.
Play with blocks.
Can I, just a second to
Yeah.
confer with Mary, because I think then what Rob is suggesting works.
Okay.
But I could have totally made a mistake, so I want to check with Mary. So what Rob is proposing, as I understand it, and please correct me if I'm wrong, start with what we have in option C, add the ID 13 solution, correct? And subtract, if you will, the ID 99 solution.
Correct.
Okay. So, option C, as currently configured, the resulting population is 3,370 for District 3. We subtract a population of 52 to reflect the adjustment for ID 13.
That's wrong. You'd be adding.
And we add 74 people to District 3 for the ID 99 adjustment?
Correct. Both of those are additions.
How can they both be addition, because 1 is already currently in the district?
Because 1 you're taking out and 1 you're putting in.
Because 1 is not already included in
But 1 is.
option C, and 1 is.
The 1 that is included we're removing, and the 1 that isn't included we're adding. So they both make adjustments to these totals.
But both shouldn't make positive adjustments.
1 is already in the option C. Which one is already in the option C?
99, isn't it?
99 is already in option C.
So let me go through it one by one for you.
Okay, let's do
With the
that.
populations of option C,
Right.
we are first going to remove 99 ID 99.
Out of which district? Everyone say which district when they're saying these.
So we're removing, we're removing from the totals, we're removing 74 people from District 5 and adding it to District 3.
Yeah, adding it back in.
Right.
Correct.
Okay,
Somewhere else, yeah.
okay.
So then
It's
we
the
are
ID 13
we are
that's missing.
adding
Then
ID
you go
13.
Right.
which says from District 5 to District 3. That one's easy because it's an add. So it's District 5 to District 3, 52 people. So you're adding to District 3 and you're subtracting from District 5.
Okay. Thank you.
So we've added 126, well, no, I'm not going to say anything, let Dwight.
I think, yeah,
And then we need
these numbers
class
work
size.
because, again, sorry, I have to keep this simple or I confuse myself. Our range is 3,258 to 3,600. Option C, with the adjustments that Rob has described, results in a population in District 3 of 3,496. That works. And it results in a population in District 5 of 3,334. That works. Both of those numbers are within that 5% range.
Did that include that piece right there?
No.
Oh, so we didn't have to move that?
No. Yeah.
Well, that's what I thought. I thought we wouldn't have to add to 5, right?
Well,
What did Jack just ask? What?
he just asked about this.
That was Mary's proposed, maybe we needed to add back in to make up that 126 that were being adjusted. But I then I stopped because I figured one person can calculate. I wasn't on board with the numbers. I'd like you to check those numbers, though.
Plus 74.
I'll do that too.
Oh, wait.
No, you're below the 3.
Yeah.
George is below, that's why I thought you needed that one piece, and then it really put collectively in balance.
Well, that's what I thought.
Yeah. No, we're still good.
But I stopped my thought.
I think we're still good. 1%. By 2. All right, let me back up. And let me just walk through it one piece at a time. District 3, option C, the starting population, if you will, is 3,370. To that, we add the population of ID 13, which is 52, and we also add the population of ID 99, which is 74. The total there is 3,496.
Well, stop right there. District 3 already has one of those
District 3
In there.
is 74.
it's already included.
On option C.
But what we are saying is that we are not, the option C assumes that that population would be transferred from District
3.
3 to 5, okay?
So it's,
And this adjustment that Rob's talking about is, let's do option C, but not make that adjustment. So therefore, in the ending population of option C, we add that population back into District 3.
Okay.
All right? Now, District 5, option C as presented is 3,312. We subtract the population in ID 13, which is 52. We also subtract the population in ID 99, that's 74. We end up with 3,260, which is 2 people more than our minimum population. So I think both of those work.
That's not the number I get. I get 3,186.
Yeah, I must be doing something really crazy.
District 5 starts with 3,312, minus 74, minus 52.
I beg your pardon.
You get 3,186,
You're right.
which is,
186.
with 3,258 as our threshold number, it's 72 people off.
And that's why we need that
Okay.
piece.
I'm sorry. This is My mentor as a young associate had a maxim, which is lawyers should never do math.
Okay.
He's just proven the truth of that. But Rob is right. His numbers are correct.
And so,
So we need more in 5.
Which this
Represents how many?
69.
Which would be 3 people off now.
Which is not close.
yeah. I mean, the only thing that really strikes me, guys, is that one District 5 is a wraparound of almost the entire county, and, you know, that's fine, it's George's district, but talk about going to caucus meetings and homeowners meetings to try to stay in touch with everyone, it's pretty disjointed.
Oh, yeah, I mean, yeah, as it is, you know, last night was an hour up to Frying Pan, the week before it was an hour up to Redstone.
Yeah, an hour up to above Rob's district and Rob's house and my district and my house. It just, that part starts to feel, I know what we're trying to do in the Snowmass Canyon area to keep that whole, but it just starts to feel,
Yeah, I mean,
What about-
already what you do, George?
what's interesting is I never even realized I had part of Snowmass Canyon. And so, it could almost be status quo.
let me,
Otherwise, I'm going to have to ask for an airplane.
yeah.
Or change your residence to a more central area.
It's the heart of Pickens County. We're the epicenter.
You just said you're not near anywhere.
Yeah, that's we're the epicenter.
Jack?
So, Mary, would you mind going back to that little last piece we added 59 to 5? I'd like to get a little more understanding of exactly where that is. Is that the Independence Pass Caucus?
Not quite. The east of Aspen?
Yeah, east of Aspen,
East
thank
of
you.
Aspen, the caucus area, is that east of Aspen? Is part of it, would be in here. So it does not incorporate the subdivisions, you know, Mountain Valley kind of ends up in here, but it would be.
And Knollwood and all that.
It would not be those, it would be
No,
the
those are
more
Rob's.
east and bounds properties up towards Taggart Lakes, the campground up here, and then this is Taggart Lakes here. So that's where your population is.
What district is that in currently?
Currently in 1.
That's currently in 1.
It's Wildwood and
Yeah.
Yeah, it just, again, it's just such a wraparound district, it starts to feel funny. I can understand the issues of keeping this kind of, and I'm looking at this little map that Dogtail in 4, because you were saying that that's the, you know, Capital Maroon, old Capital.
That's Gateway, Snowmass Creek Road. It's the whole entry to Old Snowmass.
I can tell you next month, there are 3 people moving from the Woody Creek Caucus to this area because their house is going to be done and they live right now on Little Texas Road.
And we're going to see the eventual blowout in Burlingame, and so there'll be another 200 people in my district. So, but George, go ahead.
I guess my question is to the board, are there any other discrepancies or issues with option C? Because if not, I would just leave option C as it is.
As it is, or as it was amended with this discussion?
As it is,
As it is.
yes.
Okay.
Because, again, it hasn't been an issue with Lower River Road between the 2 districts ever.
I just see that as a discussion between you and Michael as to a little bit of the representation, because they're where you're contiguous and you feel comfortable with what's gone before you.
As I said, I never even knew it was in my district.
Yeah.
You know, I think that actually the modified one works better, because it puts both sides of the road in one district and you're done. And
Yeah.
then, you know, there's really not much you can do about District 5 except increase the size of it. That's just the way it is.
What's funny, as I say, I kind of keep watching 2 shrink It's down. We're gaining because of this, but it's still, will be the lowest number of constituents of any of the 5 districts unless these modifications are made to 5. It's down at 3,288, and you see other things like District 4 get up to 3,600. So, I mean, it's a full 300 population difference in that district. There's almost 300 difference between one. It's the lowest population district is mine, and so it keeps kind of shrinking.
And it should be, because that's where you're right in the core.
Yeah, well, I know, but it was just to even out the numbers, and I understand there's been population numbers. I'm not saying there's anything wrong with it, but, Burlingame got added in, Main Street got taken out, and it's gotten leaner there. I don't know if there was anything else to add into 2 that would then help even out the 5 situation, but that, coming into there, but
I 5 aren't contiguous, that's our only problem.
Yeah, that's right. 1 is the only one that's contiguous, so you'd have to bump something into 2, take it out of 1, take more 3 into 1. It just gets pretty...
Is there anything that we can add from District 4 to add back to 5? Because District 4 is at 3,607, so it could theoretically lose up to 300.
Right, but...
And all we need to do is gain, and I
72.
District 4, I have the census stuff here, though.
it makes sense to add to 5.
Yeah, it makes sense.
I'm saying, I'm not saying just randomly with numbers, but
I mean,
I don't know what's in that maroon, where all that wilderness is. There's no one living up there, so.
If 4 comes down and maybe starts, this is their census block, so the darker the number, the more the population. You could probably even look into the Owl Creek area, but I'm not sure that's where you'd want to be.
Well, we'd have to go to District 5, so that's not connected to District 5.
4 would go to 5. So this is like one really large census block that has 30 people. This is very rural. The light is flashing here. That one is flashing, that's 30 people, and it's a rural district. So
But that's already in 5.
that one's already in 5. So you're looking at what comes out.
To take away from 4 and add to 5, if there were something that made sense.
Yeah, but
Now,
then
we
you're-
already decided that the Snowmass Creek area does not make sense because we thought that should stay in 4.
Yeah, this is
That's
that
299 people.
Monastery Child Ranch. That's this whole drainage in here, and there's nothing really contiguous here that you can easily
Pop over there.
logically put in 5.
And so if we made those 2 adjustments to 3 to unify that area more for Michael, it does put District 5 under the minimum of the 5% variation
Correct.
by a pretty significant number.
By, 72?
But we've added in that piece.
We could add back to District 5 the 69 people in that East Highway 82 parcel that Mary showed.
Yeah, up above
before.
town. But again, I think that was what George was saying, it's getting a little skewy.
No, I understand.
But, it also, to me, there's a point at which there's supposed to be some opportunity for representation across the valley. And I know we've heard from Redstone before and others as to whether there should be just district voting, only elect your own people. And this is kind of saying, well, those Redstone people or, Emma, whatever areas, Brian Hancock is, they also may have to compete with someone who basically is a resident of Aspen, not, for that seat. I mean, it literally throws back in the dynamic of having a contender and having 3 people literally represent and live within a mile and a half of the gondola, as opposed to a better opportunity that someone will be elected from the Mid-Valley and the Down-Valley regions, such as happened with George. So that's a little my concern about throwing in just one more parcel, that is diametrically opposed, distance-wise from Redstone, across the county, one district that reaches all the way across.
But the gravity of Aspen, the mass of Aspen,
really
just
is
does
the
that.
problem.
And that's the difficulty, that you don't have dispersed population centers. You only have one concentration. So unless you do pie cuts into Aspen, you're not going to get the kind of population you need.
Well, no, but what I'm saying, Michael, is that we would be deliberately adding additional in and making that dynamic more distinct. If we, to even out George's district through a little more in of actual population up here behind 5, I just starting to wonder whether that's logical. Or, I understand what you're saying about uniting those regions down in Snowmass Canyon. I truly understand that, and that makes sense. But I don't know if I want to do something illogical over here to make logical happen in your district.
I mean, District 5 has always been known as the Down Valley District.
This makes it the Up Valley
It really throws
district.
things out of kilter,
I agree
think.
with that. It does, I think your point is that somebody who now is on the east of Aspen can be a candidate for District 5, and I think that's a very legitimate concern.
So we should, if I'm understanding the conversation, the last piece that we looked at those 59 people, I think it was?
I think it was 69.
Yeah, whatever it was. That really should not go to District 5, because that
You
changes
mean
that
go from
dynamic
District 5?
of everything. When I think of your district, it really is not consistent, and I wouldn't really want somebody to run from there. We really need a Down Valley, quote-unquote, commissioner. So if we don't do that, but we left the other two, 13 and 99, how far off is George? It looks like he's not too far off.
Well, that's what I was just going to say. Maybe
3245 versus 3258 is the minimum number.
But what if you just left one of those two in George's and one of those two ID numbers merges with District 3? Does that get a little closer to...
I look at that, Rachel, but look at what our topographical or, bird's eye view of Michael's district. It would mean not doing District 3 to District 2. This is, I apologize, I don't have that 99 in front of me, right? Okay. So, District 3 to 5, we're saying we would not do that one and we'd leave that in George's. So that 74 population would stay. But number 13, ID 13, that definitely needs to move to District 3. I know it takes away a little bit of Georgia's population, but it wouldn't make that gap so much. This seems, maybe I would agree with not doing ID 99, but I think ID 13 probably should definitely be.
What I get with some rough math here, if we take option C, and District 5's population is 3,312 under option C, and then subtract what is this minimal optimal number of 3,258, the most George's district could lose would be 56 people. And so if one of those two, ID 13 or ID 99, we'd wanted to add into District 3, again, as long as we don't exceed 56 people lost from 5, we would be okay. Either one of those two ID numbers, one ID 13 is 52 people. That
Right.
that would mesh without putting
But
George...
if we gave, go ahead, Rachel, I
No,
apologize.
without putting it under the number. I don't know, I didn't write down here, how many people did you say were in ID 99?
74.
74, so that's the one that, really pushes us a lot closer to that edge.
So in other words, if we do, please correct my math again, but if we do option C with the ID 13 adjustment, but not the ID 99 adjustment,
It should be within range.
you are within range, I believe. You're at 3260, which I think is the bottom range.
Yeah,
Two.
two to spare.
Two to spare. Who may have already moved out or in.
Now, I'm not looking at the map, so I don't know if ID 13 is more or less logical than ID 99 to hook into District 3.
It looks like 3260 is that number by doing option C and not doing ID 13 because of continuity. Michael, your feedback, of course, is important here, but that ID 13, I just feel certainly that that is part of what I've always thought of as District 3.
So ID 13 is the more ideal one to connect with
To
Michael's
stay in,
district.
as opposed to down Lower River Road.
So, again, one last shot here. If ID,
Well, they're both down Lower Road.
Well, I
but
understand,
One's on one side of the road and one's on the other side.
so you would end up with not getting those two connected in the same district.
George said it, he never even looked at that as,
Well, it's still sort of a flagpole for George, it seems to me.
What do you mean?
More than a flagpole of east of Aspen would be.
No, because it's sandwiched between District 4 and District 3.
It would be 5. This is the 5.
Guys, can we maybe say that we've played with this as far as we can get it today, and we know where some of the dilemmas lie and what we're trying to accomplish, and let you guys play with the maps and numbers a little longer?
Yeah, it's very difficult to do this contemporaneously.
well, what I get, if we took 13 and 19 and didn't act upon those numbers.
99.
Yeah, 13 and 99, we're 50, George is under by 50. But look where we were by the end of the census. I mean,
We were off by quite a bit.
Well, by 1,000.
yeah, Michael and I are, I'm 1,000 and, let's see, yeah, Michael is 1,000 over before, I'm over 550. Now I'm over 7 under this thinking, and George would be under, but everyone else, 3 would be absolutely in, George would be under, and we just have to look at the crystal as a population generator. And, but I am over 7.
Yeah, Rob?
Last quick question, and then I'll let everything go. In ID number 12, is there any way of not removing the old Snowmass Creek that I think should stay in District 4, but taking that top little section, and if there's 72 people in that top section somewhere, that would make the difference.
Which top section?
This top section here?
That
Was
a census block.
That entire thing
That's
is
One census block?
one census block.
So there's no way of dividing one census block?
Correct.
Actually, this
Oh, I'm sorry.
funky line here
Yeah.
will adjust to here. We're already counting this census block population in 5, even though there is this funky little thing. None of the houses and none of the addresses are actually in this jog.
In
That
this
was
jog.
an old census configuration.
So there's no way of dividing that, pulling 72 people out of that lower part, like that census block?
That has 4 people in it.
you mean right here?
Well, we want to keep this in 4. But if we can somehow get, maybe somewhere on 82, those people into 5, and all we need to do is balance 72 people.
But they're already in 5.
No, 30.
No, 4.
This is 4 is right
District,
here.
well, District 4 is this line.
Oh, got it. Yeah, that's existing.
Yeah,
Yeah, this seems to be by Grange property or something, in basalt almost. Is that correct?
right here's Highway 82 and Snowmass, Conoco would be right at this intersection.
So there's no division of census blocks in there, is what you're saying?
Nothing that's, are a couple, let's look at them. There's this one which has 4 people, but that's it. Other than jumping into,
That whole block.
You'd get some from Eagle County.
I'm sure they would appreciate that.
Yeah, they love a reduction in pop.
the parcel lines, that's confusing. So this is the census block here and here, so
So how many are in that one?
this one, and that is, this is Gateway here, so it's all the properties
That's
around it.
36.
It's 36.
So that's 40,
But what you're doing is taking,
Yeah.
You're splitting that caucus area then?
That's like so historic.
Right, yeah.
Yeah.
it's not logical, but it's,
I guess the question for me is to ask George if he's okay being 50 down, because that's an important opinion, that's his district and there's compliance.
or
State law, I mean, your introduction is state law is 5% for the congressional districts. We've adopted that by policy. 50 people, just, that doesn't even make up half my condo complex.
I'm
Not worried about
Well,
that.
let's send that back to them to work on, that
Well, that's-
particular problem.
Well, that's what I was kind of saying. I think we may have taken this about as far as we can get to understand some of the desired outcomes in terms of more to unite in 3, and how, if it's possible, to then make sure that 5 hits the minimum threshold. I would, again, note that District 2, where I live, is just 30 above that minimum threshold right now. So, some of us are pretty close to that minimum threshold. Every 32 people, 32.8 people is 1%. So, 50 of 1% of what you're supposed to have. So it is meaningful. It's hard to say, But if you can try to look at that and present us some options, what I would maybe particularly request is, and this is just coming from me, but because we are getting closer, if we could have one regular old-fashioned blow-up map. We don't need one for everyone, I don't want to waste a lot of ink, but as you get to showing what this option is, that we have one blow-up of the county of option C that you seem to, and so we can take a look at that.
so,
These are just still, even on the projector, they're still so hard to see.
so this one blown up
Yeah,
with more detail.
with more
This one
detail.
meaning what, this one?
C, option C.
Option C, cover page.
Yeah, and with what you've been able to determine, it may be that we reach a conclusion similar to what Jack has just stated, that with George's support, that, maybe a standard deviation of 7% is going to be acceptable in some areas.
I can make that up in cattle.
We'd hope.
Maybe it gives few people to get roommates.
You like cattle go to the polls?
I got the cattle just moving right next to me.
But
Yeah.
I do think we're seeing the primary objection to not adding a far corner of the county to the other far corner of the county.
That is
Okay. Did anyone have any other issues that we did not really get a chance to get to? Is there anything else that we had to skip over with open discussion or anything like that?
Just real quick, to John, I guess we will need another work session, and then first and second reading of a resolution, all to happen in September.
Yeah.
Okay. And I can deal with Susan on that.
I think we're getting very close, though, and I'm not sure if we might have a little bit of an extended MOA time on one of these ones and try to put it in under MOI, because we're down to the fine grain here on this one. Okay, anything else from anyone? Well, then we will end the meeting. Thank you, Grassroots TV. Appreciate your time here today, and we will be back here at noon tomorrow.
Thank you, everybody.
Thank you.